Good morning, ladies and gentlemen. Welcome y'all to the House Public Safety Homeland Security meeting for this morning. We've got a couple of issues before us today. Senator Stone here. And we'll move to the other bill first then. Before we start today, we've got a couple of bills, one of them that may have a certain amount of emotion involved in it. So what I would recommend, first, let me ask if everybody would cut their phones off. If not, there'll be a fine imposed. We're going to try to keep order because of the volatile nature of possibly one of the bills. We have security in here today, so if everybody would be on your best behavior today. Well, Senator Stone is here. Out of courtesy to Senator Stone, we're going to hear, Senator, if you would, just have a seat. You're not late, Senator. Before we start the meeting, we've had a tragedy in the public safety arena. We had a young trooper that was killed in an off-duty accident yesterday, hydroplaned. Tyler Parker from down, I believe it's Crisp County. So if we would, let's give a moment of silence in his memory. And then I'd like to ask Representative Glanton, if you would, just say a word of prayer.
May we pray. Most loving and gracious Father, we just come before you on this day that only you could have granted us. And Father, we thank you for being the great I am. We know that you would lift up the trooper's family, Father. We pray today that you would be with them, that you would guide them, that you would uplift them, that you will show your face to them as they experience the roller coaster of emotions, oh Father. Father, we thank the trooper for his service to this state. And we ask that you will continue to take care of his family, his children, his family extended and beyond. And Father, we ask that you would bless our state troopers, all of our law enforcement, God, as they go about the business of protecting us and keeping us safe. And now, Father, we ask that you would bless this meeting and the leadership of this meeting as we go about doing the business of great Georgians. We ask this in all things in the mighty and unmatched name of Jesus Christ. Those in agreement say,
Amen.
Amen.
Thank you, Mike. Let us all say prayers for the trooper's family and his young daughter that was injured in that accident. Senator, we have a substitute. The subcommittee has been working on a substitute. Have they given you a more recent copy of their substitute?
You have an extra copy now.
Let's see. You got an extra copy?
I can give him mine.
Fine. Thank you, Senator. To the committee, you should have the original as passed version of 452, subcommittee substitute, and it'll probably be a interesting testimony and debate this morning. Go right ahead, Senator.
Senate Bill 452 does something that most of us thought should already be the law. We've passed bills, in the last 10 years that dealt with requiring local governments to cooperate with ICE in enforcement of our immigration laws. Now, there's been resistance in the area of ICE detainers, and some local jurisdictions have pointed to the permissive language in our state statute that does not require reporting from law enforcement to the ICE authorities. This changes that in most places where there had been may, it's now shall. And this starts from the time an illegal alien enters into the law enforcement arena until he exits, he or she. The arresting officer is, if he has information that would indicate illegal status, to provide that information up the chain of command to the prosecutor. And the prosecutor can use that in presenting the facts in front of the court as to setting bond and other issues that might be impacted if we're going to cooperate with the federal authorities. Then it moves on up to the court. And here's where we had a change. The original bill provided for the judge to comply with this noticing of the federal authorities. Our judges came back, provided feedback that that was something that they were not equipped to do individually, so we amended the language to simply require the judge, if that information, to make the inquest, to ask about inquiring into the status of the defendant in front of him. And if he is determined to be illegal, to direct the prosecutor to inform the federal authorities. Moving on up to the Board of Corrections. When an illegal alien enters into our correctional facilities and is serving time, before that time expires, that is 72 hours before the person is released back on the street, that to check to see if there is an ICE detainer on that person and to notify the authorities that that person is in custody. Now, what the handout shows is that there are quite a number of illegal aliens incarcerated in Georgia prisons. The most recent information I have provided by the Board of Corrections is a total of 1,360 inmates. And these are people who are not incarcerated because of their status as being here legally or illegally. They've committed and been convicted of crimes. And it's those types that we need to cooperate fully with the federal authorities in to allow them to process deportation or whatever appropriate remedies there are. And that's consistent with the priorities set in the previous administration of President Obama. That is putting the priority of getting the dangerous ones deported first. Now, we're not selecting, limiting it to that, but we are at least facilitating that through this bill. And we have also on this bill incorporated at the suggestion of Representative Petrie some public reporting so that the public can be knowledgeable about the population of inmates who are here illegally. And this type of information that you have here on the spreadsheet would be the kind of information that on a quarterly basis would be made public. This is not something that imposes a big burden on the corrections, because they already keep track of this. So yeah, I think most people would agree that the public has a right to know that there are child molesters, murderers, robbers, rapists, and all these included in this population. And I think that these are serious crimes. These are not traffic violations. So now, one thing I'll point out, by requiring the notice be given 72 hours before release, we're not holding them beyond the term that they're lawfully in custody for. So this is not adding a burden to the state, and it's not violating any inmate's civil rights. With that, I'll be happy to try to answer any questions. I think it'd be better for y'all to present the changes, because I have not had an opportunity to go through it yet.
Thank you, Mr. Chairman. Mr. Clark.
I'm going to just talk about the latest substitute real quick, and then just to present that. In Section 1, we did change a shall back to a may. There were some concerns within the business community. A lot of international with international companies, a CEO or somebody might be here with a foreign driver's license, and if they were pulled over for some reason and they didn't have their visa on them, that, you know, most people don't carry that around on them on a permanent basis, because they don't want to lose it, because it's a pain to get another one. That we wanted to allow for discretion, the police officers to maintain some discretion there. So we changed it back to a may.
Well, what line is that on?
That would be on line 19. So allowing for, I mean, because this isn't Nazi Germany where we're not asking people to carry their papers around on them at all times. So we made that, we kept that as a may. We did take out the section that required with Representative Petrie's database reporting on the Department of Corrections website. That's been removed. Also, the previous section that would have prevented bail, or I don't have. Let me look at that part real quick. I think it was. Yeah, the parole and bail, where that was changed from a may to a shall. We're going to ours takes out section. Well, in the past, the part that was passed by the Senate, it was section 4, lines 90 through 94. That's been removed to just allow that to continue to be a may instead of a shall. Again, not wanting to prevent somebody from allowing the judges to have some discretion there as well on potentially not detaining somebody that doesn't need to be detained or paroled. And then I'm trying to remember it's changed a lot. We did limit it back down to only felonies. The part that passed the Senate in Section 2, it dealt with felonies, misdemeanors, or ordinance violations. We pared that down back to felonies, just talking to people. We do want to capture the bad guy. I mean, the people who are a threat to our society, in our country, the ones that are committing, felony acts, to be able to detain them, turn them over to ICE, and have them sent back to their home country is something I think we can all agree on. I think even talking to people while working on this who are representing some of the people concerned with this, they were even on board with the felonies, because it would be the ones that are a threat to society. If you do capture them, it relieves the burden on our society. So those are some of the changes that come to the top of my head as just trying to look through the comparison over the last. You've kept me busy over the last week and a half working with people on the committee and people of interest that were concerned about this. So,
Well, any common sense changes are appreciated.
yes, sir. So that's pretty much the new substitute. I think it's trying to capture the heart of what was trying to be done in a way that still protects human rights and protects our society as well. So, with that, Mr. Chairman, that's the substitute.
All right. Let's see. Mr. Petrie.
Yes, sir. Thank you, Mr. Chairman. And I first have a question, then I want to speak to my colleague here. First, for the senator, so some of the changes that I'm just seeing as well for the first time, and all of us, most of us, these shalls becoming mays. Ultimately, you began by pointing out an issue we have.
Right.
That the current law is not being enforced. Does that, do we accomplish anything if we change those shalls to mays?
The area of non-cooperation is with the local authorities. Most
Right.
authorities cooperate, but
Sure,
there are
sure.
pockets that don't.
Right.
So-called sanctuary jurisdictions. I don't know is my answer to that. I think the state of Georgia, our own authorities that are directly under supervision of the governor and legislature, I think we can give some latitude, but it's the non-cooperative local jurisdictions that if you change may to shall to may, may not solve the problem. Now, limiting it to felonies might be less of a problem than
Sure.
changing shall to may.
That makes sense to me as well, and
Yeah.
I, like you, think our goal is felons. So my second point is to my colleague here. So the information that I passed out today and that I spoke to the Department of Corrections Commissioner about, and let me first, just for everyone here to be aware, I've spent several years over the last few years working on parole reform of legal citizens. And one of the things I've focused on is transparency, because I believe that everybody has a right to know who we're letting out on parole. We're talking about legal citizens. So my interest in this bill was adding to something to your bill that I thought was very important, and that was transparency. So the information you alluded to that everybody here has before them, I want to mention a couple of things. So right now today, there are 193 child molesters who are offenders with ICE detainers in Georgia prisons. Okay? I want everybody here to hear that. There are 134 murderers, okay, who are here on ICE detainers in Georgia prisons. There are 103 armed robberies. There are 100 aggravated assaults. There are 98 rapes. There are 65 aggravated child molestations, 61 kidnappings, 45 volunteer manslaughters. And here's what I wanted to add, and here's what I did add, and I'm going to make an amendment to add back to this bill. Not that anybody's personal information is given, not anybody's name, not Joe Smith, but that the public has a right to transparency. The people have a right to know the degree to which this issue impacts them and their their safety. This information should be public knowledge. I'm able to get it as a legislator, but my constituents don't have access to this information. And the amendment that I had offered would require that this information, just these raw numbers, the 1,360 of these felons that are in our state prison system. It has nothing to do with jails, nothing to do with our sheriffs, but that this information would be transparent to the people of Georgia. Is that not correct, Senator?
I can't argue with that.
And so I want everybody here to be aware of what my colleague just spoke to trying to remove from this bill, because I will offer an amendment to add it back.
Mr. Clark.
Just want to make aware that the removing of that section came at the behest of the Sheriff's Association. So that was, it wasn't just me doing something willy-nilly. It was the request of some people. Also, the information, I supported my colleague last year on a measure that when these people, these felons who are illegally here, serve their time and are released back into the general population because the home country will not receive them, I supported his measure to have that kind of information shared with the public. I don't know if knowing this information is vital to public safety while they're in prison and detained. I mean, if you have 7,000 child molesters in prison and 193 of them are illegally, I think it's more important to know that there's 7,000 child molesters in population, and then once you release them back into population, if a felon is required to, they've served their time, and we're not going to force somebody to stay in prison forever because that's inhumane, I guess, and their home country won't take them back, then I don't have a problem with putting that information out to the general population, because then I do think that that's when it becomes a public safety matter. I don't think it matters while they're in prison if they're 193 illegal child molesters or 7,000 child molesters in prison. That's just my take on that. That came at the behest of the Sheriff's Association because they feel like it would become a negative knock on them, that people would question whether or not they're doing what they're supposed to do if the people are in prison instead of being sent back home. That was where that came from.
All right. Mr. Petrie.
Yes, just to that, first of all, I don't represent the Sheriff's Association. I represent 56,000 Georgians. And here's what I want. I believe in transparency. It's not our place here to determine what the people of Georgia know about their public safety. If indeed 134 murders were committed, and yes, I'm not suggesting in any way that our U.S. citizens aren't committing plenty of murders, Lord, far more. I understand all of that. But those 134 murders were murders that were committed that never should have happened, because these are criminal, illegal aliens who are here in the country illegally. The public has a right to know. They can make their own decisions about what policy, whether they choose to support the senator here or not, they can do through this body. But the question you will answer today is, do you believe that the people of Georgia have a right to know this, or do we keep it secret from them like we're doing today?
All right. We have any other committee members have any questions before we start taking testimony? Interesting. Do we have a list of speakers?
Mr. Chairman,
I'm sorry, Mr. Holcomb, did you want to?
Mr. Chairman, do you want me to sit elsewhere?
You're more than welcome. Anybody wishing to speak, they can speak from the podium over there. And if what I'm going to restrict somewhat your time. If you would, try to keep it to a minute to 2 minutes for those of y'all that are testifying, and if there's any redundancy, just get up and say, I'm redundant. All right?
I love that, Chairman.
David Schaefer. Am I not pronouncing that? Oh, I'm sorry. Mr. Holcomb.
quick question in terms of the transparency aspect. I recognize that there are a lot of people here, and I think that the substitute that we're working off is freshly released. Is there a way that we could provide copies to those who are in attendance? Because I would certainly welcome hearing some of their feedback on it.
I'm sure that they could, but I think that they've already heard what's in it, and we do need to move forward with this. Does anyone out there like to see a copy of the substitute? All right. Very good. It'll be shortcoming. Mr. Schaefer?
Mr. Chairman, good morning. Committee, thank you for allowing me to speak today. I'll be brief. My name is David Schaefer. I'm with the Latin American Association here in Atlanta. We're the largest Latino serving nonprofit in the state, and we serve about 40,000 Latinos a year. From what I'm hearing of the changes, they've dealt with a lot of our concerns with the bill. I have not seen those changes as we just discussed. So I would put forward a concern that we always have with this kind of bill, and that is the question of what it does to people's willingness to report crimes to the police and what that ultimately does to the cause of public safety itself. So I just wanted to put that forward. If we do things to discourage people from calling the police, it might ultimately reduce the net sum of public safety that we have. So that's all I have. Thank you.
Thank you. Bubba Samuels? Good to see you, Judge.
Good to see you. Good morning. Over here. Mr. Chairman, members of the committee, thank you very much for the opportunity to appear before you today concerning SB 452. I appear today as a representative of the Council of Municipal Court Judges of Georgia, and I have here with me Judge Lee of the Duluth Municipal Court and Judge Jackson of the Atlanta Municipal Court. I currently serve as the Chief Judge of the Monroe and Franklin Springs Municipal Courts, and I serve on the Municipal Court Training Council. We have just received the substitute bill, and we commend the work on the substitute. We do still have some concern regarding what may have been an oversight for consistency's sake within the bill, specifically in reference to lines 79 through 81. That leaves, does not restrict those probation requirements to felony cases. It still includes misdemeanor and ordinance violation cases. And so that would be problematic. My prepared comments were in reference to the original bill. So let me emphasize that all judges are committed to the rule of law. However, for various reasons, the council could not support SB 452 in that original form, and I think if the change requested specifically to line 80, removing misdemeanor and ordinance violations from those probation requirements, if that change is made, I think that from our perspective, our inability to support the bill is resolved. As originally written, the compliance requirements, particularly in Section 2, were very problematic for our courts, and we estimates are close to $500,000 in a single court in terms of the necessary training, management, and disposition of cases due to additional personnel that would be required to comply with those requirements. So again, we commend the substitute bill and would request that it be cleanly modified to remove those additional unfunded obligations of the municipal courts. As you know, the majority of our judges serve on a part-time basis. Some of our judges are not attorneys. Unless we are removed from the ambit of the bill completely, additional training is going to be needed. Not all of our municipal judges are even attorneys, and so substantial additional training would be required. And Judge Lee, I believe, is signed up next, can speak to that additional training that would be required. Importantly, I would note that law enforcement officers run records in the field when they write the tickets, when they make the arrests, and an ICE hold, if it's found, the defendant would be detained. Under even the substitute bill, as it's currently drafted, the court would still be required to run an NCIC record check to determine an ICE hold, but even that check would only deal with the time gap from the time that the officer made the arrest to the time of sentencing. And so the onerous unfunded mandate, the onerous education and training requirements and additional staffing requirements, we feel are substantially, that those additional burdens substantially outweigh any benefit from capturing what would be, in some cases, just a couple of weeks of whether or not ICE had placed a hold in the interim. So again, Mr. Chairman, committee members, thank you very much for your time, and the Council of Municipal Court Judges appreciates your service.
Thank you, Judge Samuels.
Thank you.
Judge Lee?
Good morning, Mr. Chairman, ladies and gentlemen of the House Committee. My name is Chung Lee. I'm a municipal court judge from Duluth Municipal Court. They have asked, the Municipal Council has asked me to speak a few minutes on the issue regarding the impracticality of having judges and local law enforcement to make determination regarding basically the person's immigration status. I've been a member of the bar for 35 years and also been a member of the AILA, which stands for American Immigration Law Association, which is one of the largest immigration attorneys are in the United States and internationally. And I had a privilege to give lectures before the State and Supreme Court Judges Council and their conferences, Municipal Court, and also State Bar of Georgia. The immigration law is very complex, and it changes constantly. And every day we receive statutes and regulations from AILA and from the state, from the Department of State, from the Board of Immigration Appeal, AAO, from the USCIO Appeal Board, from the District Court, Appeal Court, and the Supreme Court of the United States. We try to keep up with these cases and citations to help our clients if you're an immigration attorney. Simply asking a municipal court judge or simply state or Supreme Court judge to understand this text that I brought this morning. It's a law source book that we use as a part of our immigration law practice. You can see the volume of this, and this is updated every year. And the attorney who was the past president of the AILA, Earl Gertman, he published this book every year, and we as immigration attorneys have to basically understand this source book for us to practice immigration law. Asking the municipal court judges, asking the state court judges, and asking the Superior Court judges to make a determination when a person comes before you to sentence that person is like asking a civil trial practitioner to go before the Superior Court and be able to defend a criminal defendant in a homicide case. Basically, that person, if he had no experience and knowledge, actually trying case before the Superior Court of a homicide case. It'd be very difficult for that person to learn the basically procedure, criminal procedure and Constitution to protect that person. It goes the same thing, the same similarity as for the judges to understand this textbook here, basically, and within 5 to 10 minutes, and maybe even less than that, because as you know that judges, we really don't have that much time to really make a determination of inquiring a person whether this person is illegal alien. And the terminology we use in a federal statute is not whether the person is legal or illegal. We use a term, what we call lawful or unlawful presence in the United States. There are cases where they come to the United States, yes, illegally, across the border. However, under the certain circumstances, they are able to change their status to become a legal status. For example, a person came from El Salvador or Guatemala or other countries that have temporary protective status. This is where the executive order by the president allow these people to come to the United States, and because of condition of their country, they're allowed to apply for certain status to become legal for that certain time period. For those people who come to the United States legally through a non-immigration status, such as visitor status or work status, L status, M status, or P status, or other, there's numerous of non-immigration status that they receive at the embassy. They are allowed to stay in the United States until their time expires, and then they can change their status to not the non-immigration status. Okay, and so to determine that that person is illegal, lawful or unlawful status is a very difficult process and takes a long time. And so asking this board, basic committee, to consider that the person who is, whether it's person unlawful or lawful, is a very hard determination for that short time period. I thank you for your time. Thank you.
Thank you, Judge Lee. Are you signed up, Judge?
Mr. Chairman, I'm Judge Jackson of Municipal Court, past president of the council. The substitute solves just about all of our problems. The original bill would cost my court alone over $435,000 just in personnel to hire the 7 warrant officers we would need to run the records. And again, as my colleagues pointed out, there's a very short gap between the time of ticket issuance and sentencing. And the inconvenience to the public would be just monumental. But this substitute, I think, with the one change in line 79 and 80, solves our problem and leaves, as your colleagues indicated, getting the most serious people addressed first. And we thank you for that substitute. And again, we do support the rule of law. It's very important that we obey the laws, and whatever you pass, of course, we're going to obey. But the original bill, we just don't have the resources to handle that kind of unfunded mandate. And we thank you for your service. Thank you.
Thank you, Judge. And always good to see you here. Arturo Corso. If I could ask those that are speaking, if you see me tapping on my watch, that's my polite way of saying, get it out and get on.
Do you know me?
And to the committee members, if y'all have any questions of any of the speakers, push your button and speak up.
Good morning, everyone. Thank you. My name is Arturo Corso. I'm an attorney from Gainesville, Hall County, Georgia. The amendments sound promising. I still have a couple of points I'd like to share with you. And the first one, I think, is just an easy conversation for you all to have after all the comments are finished, and that is, why not just move this analysis to post-conviction? Once you have someone who's been actually convicted of a felony, definitely inquire. That'll give the courts and the defense attorneys, if it's a criminal defendant, the opportunity to find out and do a proper due process analysis and presentation of, okay, are you a citizen? Are you here present lawfully or unlawfully? And then when they go to prison, because that's the only people that go to the prisons are the people who've been convicted of felonies, not misdemeanors or ordinances. That seems to me to be the easiest place to deal with it. But I also had a question about the gentleman who proposed the registry amendment. I think, and I'm not 100% sure about this, but I think that kind of a proposal was offered last year, and that the GBI at that time says they were not able to do that. And I can't remember if it was a fiscal note issue or something else, but I put that out there so that everyone will have the opportunity to address that. The original 3 points I wanted to make were for the lack of definition of the word verification. in the bill. I still don't think the bill has a definition of what does it mean to have verified information, who will be the person or entity verifying it. And as Judge Lee correctly pointed out, the complexities of immigration law are such that I have personally had a U.S. citizen client who didn't know she was a U.S. citizen client because of something called derivative citizenship. She was born to an American citizen, but she was born in Mexico. And when she was arrested and taken to the Hall County Jail, who had the 287G program, the screening is, what's your name? Where were you born? Are you an American citizen? She said her name. She said, I was born in Mexico. And she said, I'm not an American citizen. So they said, great. We put an ICE hold on her. She was detained 4 months. Well, guess what? She was an American citizen. She didn't know it, and the jail screening officer didn't know it. We were able to establish that. And there are more than anecdotal evidence, examples of U.S. citizens who have been mistakenly deported by immigration. Second point is the strain on the foster care system. This is something personally I can share with you. Last year, I was lucky enough to become a foster parent. I got a permanent guardianship of a child. I later adopted with my wife her older brother. And in that process, I learned about the incredible strain on the foster care system. And that's just with citizens. If we start deporting parents without getting into the propriety or impropriety of the deportation, their legal presence, you are going to leave behind parentless children. You're going to see an increase in delinquencies. If you want to stop breaking and entering into cars and other kinds of graffiti and juvenile delinquent activities, you can't deport their parents and do nothing to replace them. So it's going to be an increased demand on the foster system. And then my last point is that since I've been practicing law 22 years and I've been in Gainesville for 20 years, I've had the unique opportunity to see before 287G and after 287G. In 2005, the then sheriff joined the 287G program. I assume you all know what that is. And they started setting up roadblocks in front of churches, in front of schools, in the ethnic areas of town, the Mexican areas of businesses. And they were pulling over taxi cabs and asking people in the back seat, not the driver, people in the back seat, passengers, for their proof of lawful presence, citizenship, social security card. It was horrible. We saw people go to jail and be deported for fishing without a license. The result in our community was substantial. Our jail costs went up, our probation collections went down, our fine collections went down, the private probation supervision company went out of business. All that income to the court system was cut off, and there was a due process black hole. I think that you all are on the right track. Thank you for your attention.
Questions? I believe you have a question. Mr. Glanton.
Thank you, Mr. Chairman. And first of all, thank you for your testimony. And likewise, thank you and your wife for adopting a child that would otherwise remain in our foster care program. My question is, you spoke about it being immoral, basically, to separate families and to deport one individual from their family here in the United States. But if I'm looking at these felonies that are listed on this sheet, which would call, most likely upon a conviction, would call for incarceration. Would you agree?
Yes.
So by definition, the person who committed these crimes would have voluntarily separated themselves from their family. Would you agree to that?
Absolutely.
Thank you so much.
And that's why that list and the representative's remark is important, because it's post-conviction. Those are people that have already been convicted and are in prison. Thank you.
Thank you. Wes Thorpe.
Thank you, Chairman, very much, members of the committee. My name is Wesley Tharp. I'm the Director of Research at the Georgia Budget and Policy Institute. I'll keep this very brief to a minute. GBPI is a nonpartisan nonprofit that for almost 15 years has monitored the state's taxes, budget, and public policies and spoken out on matters we think bear importance to the state's bottom line or its economy. Like a lot of people, I'll give the caveat that the sub certainly sounds to be headed in the right direction, but because the sort of issue is still in doubt, the question is called. I'll just raise a couple of concerns we've voiced over the course of this bill moving forward. First is that there's no fiscal note on this bill, at least at my last check. Yet it appears that the new requirements could carry some increased cost to Georgia taxpayers, especially at the local level, based on the experience of other states. In Virginia, when lawmakers in Prince William County implemented strict immigration enforcement, they had to increase property taxes and tap their rainy day fund to cover an estimated cost of $6.4 million in year one and $26 million over 5 years. And in Texas, the sheriff of Houston's home county ended his hand-in-glove relationship with federal immigration agents because it was contributing to employee overtime cost of about $1 million every 2 weeks. My second quick point simply has to do with the long-term economic impact to Georgia of these sorts of bills in general. It's important here to visit a couple of key facts. About 1 in 10 Georgians today was born outside the United States. That's up from 1 in 37 in 1990. An estimated 1 in 5 Georgia kids lives in a home with at least one immigrant parent. And about 60% of undocumented Georgians specifically have lived in the United States for at least 10 years. These are workers, entrepreneurs, and taxpayers in some ways regardless of their legal status. For example, undocumented immigrants contributed an estimated $352 million in state and local taxes to Georgia a year. An attack against Georgia's immigrant community could jeopardize the many positive ways that they're already contributing. It can also send the signal to sought-after businesses or educated mobile professionals that Georgia is a hostile state instead of the welcoming one that we are. And finally, I'd say the economic cost of things like communities living in fear and federal agents showing up at families, churches, and schools might be hard to measure, but those costs are very real. Thank you, Mr. Chairman. I'll take any questions.
No questions,
Thank you.
thankfully. Couple of judges, Judge Dax Lopez. And Judge Jacobs. Good to see you back to your old haunting grounds.
I'll defer to my colleague to go first.
Whichever one can be the shortest.
I am quite literally the shortest. Mr. Chairman, members of the committee, my name is Mike Jacobs, Judge of the State Court of DeKalb County, former member of this body. I'm joined by my colleague, Dax Lopez, also a DeKalb County State Court judge. I want to be clear that I am here to express to you not an official position of the State Court Judges Council. Our council has not developed a position, unlike the magistrate court judges, but I am here to express to you some concerns that have been shared among members of our council individually, and I do share in those concerns. Those concerns are separation of powers issues by and large. In terms of how this bill will function, and specifically the part of the bill that calls on us to make a determination of lawful presence in the United States. What you're asking us to do is to make a determination. That's the word that is used even in the most recent version of the bill, to determine lawful presence. And so it's something that goes a bit further than simply an inquest or an inquiry. And I'll say just at the outset that the inquiry is actually made when I take a plea of every defendant in my courtroom, and it's made in order to advise them that entering a plea could affect immigration status, and then ask them whether they would like me to continue forward in accepting their plea, or whether they would like me to put the plea on hold in order to obtain the services of a lawyer in what is a very nuanced and technical area of the law. So what the bill would have me do is make a determination at the outset, then refer that, actually order my solicitor, depending upon how that determination turns out. And I do want to circle back to the word determination because I think it is significant. To then order my solicitor to notify federal law enforcement issues to ultimately work for that defendant to ultimately work their way through a process that involves another judge potentially making a determination regarding the matter that I am making a quote-unquote determination about at the outset. So it either places a state court judge, superior court judges, and also the municipal court judges in the position of making an inquiry, which ultimately is an executive function, or as the bill says, making a determination, which is a judicial function. And that gets me to my point about the use of the word determination. You, as legislators, you may think that you're asking those of us in the judicial branch to just simply ask a question, as I do on every plea in my courtroom. But actually what you're asking me to do is apply the facts that I have in front of me to the body of law that I believe Judge Lee just held up a rather thick horn book, and make a determination. That determination requires due process. That determination could require a hearing. That determination could require an evidentiary hearing. And you're asking me to do it on a calendar potentially where I have 40, 50, 60, 70, and upwards of 70 defendants on that calendar. Now, of course, if I just simply ask the question, not all of them are going to answer yes. In fact, maybe none of them will answer yes. But I have a large volume that I need to handle on a morning or afternoon calendar, and I'm now tasked with making a determination regarding a very nuanced and ever-changing area of the law on which our judges are not specifically trained, certainly not as to all of the aspects of it. So there's a distinction here to be made between an inquiry and a determination. And then if in fact we're making an inquiry, well, that is an executive function. That is not a judicial function in the sense that I am then placed in the position of aiding law enforcement in their duties. If I'm making a determination, that is a judicial function, but it is a function that carries with it certain responsibilities as a judge. I can't just simply sit there on the bench without affording that defendant an opportunity to respond, and without taking full account of the law and the facts of that particular case and make a determination. The other thing that I'll note that is, and in that regard, I will say that there is another statute, 42-414C, which actually does place this function in the appropriate place. It has law enforcement officials while a defendant is in custody, whether that's the sheriff or I suppose state corrections, ultimately making a determination and then referring the defendant to or referring the defendant to federal law enforcement officials. If you're asking me to make an inquiry, you are then placing judges in the position of being in the executive chain with regard to with regard to something that another judge is ultimately going to make a determination about. If you're asking me to make a determination, there is a lot more to it than meets the eye. And then finally, and then I'll turn it over to Judge Lopez. And in that regard, when asking us to make a determination, I will once again underscore that this is something that hits pretty much every level of court in this state. So you are talking about hundreds of judges, and you are talking about a very nuanced and ever-changing area of the law that some of those judges are non-lawyers and may have some difficulty applying. And I would dare say that even for the lawyers, there would be significant difficulty because of how technical, nuanced, and changing this area of the law is. And then finally, the last thing that is an open question in my mind is that even if I'm making the determination or the inquiry in the course of taking a plea, in the course of taking a plea, I inform the defendant of all of the rights that they are waiving by virtue of entering their plea. And of course, one of those rights is their Fifth Amendment right to remain silent. Well, I've just informed them that they are waiving their right to remain silent by virtue of entering the plea in their courtroom, as to a matter that another judge is going to make a determination about further on down the line. And the question there is whether they have the right to then invoke their Fifth Amendment right, even though I've just informed them that they've waived their Fifth Amendment right. There are all kinds of difficulties that to my mind, have not been fully vetted from the standpoint of a judge actually applying this statute as written in the courtroom operationally. I see that the watch has been tapped, so I will turn it over to Judge Lopez. Thank you.
Thank you, Mike. Good to have you revisit. I had forgot your oratorical skills.
I'll give you some time to forget again, Mr. Chairman.
Judge Lopez,
Thank you,
do you
Mr.
think
Chairman.
you can cap that in a shorter period of time?
Yeah, in this instance, I will be the shorter of the two. So just to reiterate, our concern really is with the role of the judge and the separation of powers. Just to note, in the immigration context, immigration judges are actually part of the executive branch. They do fall under the Department of Justice. So we are trying to maintain, our lane, our judiciary lane, and keep our judges outside of the executive. So that's really our concern, is entirely with the role of the judge and not a value judgment over the bill as a whole. Our second point is, I do have a particular concern as it relates to my ability to order my solicitor to do anything when it comes to this inquiry. I can't order my solicitor to prosecute a case. I can't order my solicitor to dismiss a case that I think is unfair or unjustified. They make those determinations. Similarly, I'm not sure I can order my solicitor to go report anyone to any place. They have an executive function. So this puts us in a position that if I do order a solicitor to do something and they refuse to make this report to the federal agencies, that could create a certain situation where do I now have to have a hearing to hold my solicitor in contempt before making a judgment as a part of the executive branch. So I do want to raise that concern. And finally, I think, well, it was mentioned before, I don't believe there is any constitutional issues to putting this in the right lane. Maintaining law enforcement personnel, sheriffs, associations, sheriffs in different jails, they can report as needed, as wanted. And as my colleague mentioned, 42414 does require currently that report to be made within 48 hours of an individual hitting any jail. Right now, the law enforcement personnel, sheriff's personnel have to make that determination once someone is in a jail and report that to an agency if it does come up after checking someone through the Law Enforcement Support Center, LESC, as provided by the statute. So I thank you for your time, and I thank you for your consideration today.
Thank you, Judge Lopez. Do we have any questions?
Thank you.
That was the last of the judges I hope that were that I think were signed up. Just in case, am I missing any other judges? We might as well put y'all all in one basket to testify. Any other judges in here? Thank you. A double thank you. Priyanka Blatt.
Good morning, members of the committee and Chairman Powell. My name is Priyanka Bhatt, and I'm a legal fellow with Project South, a social justice organization based in Atlanta that works in the defense of immigrants, Muslim Americans, and communities of color in Georgia and across the South. I am here today on behalf of Project South to still strongly oppose Senate Bill 452. While the new version of the bill addresses some of our concerns, we still have many problems with the bill. I want to emphasize that the original version was unconstitutional in mandating detention. We still have concerns that this bill is damaging to our communities. The bill is overly broad and could have unforeseen consequences. This bill would have officers detain individuals. They may detain individuals if they receive verification that an individual is undocumented. But verification is not defined in the bill at all. Does this mean that someone who forgot their license could be detained because that would be verification that they're undocumented? Well, we don't know because the bill doesn't tell us. But what we do know is that the language is here overly broad and could allow for that possibility. It's also damaging because it creates distrust between our immigrant communities and our law enforcement, making it a hostile environment even to report crimes in fear of ending up in deportation proceedings, and therefore making communities less safe. This bill costs localities time and money and would, like I said, might be unconstitutional, and for these reasons, we strongly oppose Senate Bill 452.
Thank you, ma'am. Any questions? Thank you so much. Naomi Sue?
You did it. It's not the easiest name. Thank you, Chair. Thank you, members of the committee. Thank you, Representative Clark, for all your work on changing this bill, and I look forward to seeing a copy of the new bill. I commend the change from shall to may in Section 1. It avoids making this bill into an unfunded mandate with regard to local police officers who would have to risk running afoul of the Fourth Amendment and detaining people without any probable cause of constitutional or probable cause of criminal activity, and also not providing any extra money for training the officers or for hiring extra officers to do the work. I do still have two concerns with regard to what I understand the new bill to say. I should say I'm from the Southern Poverty Law Center, our immigrant justice project. With regard to transparency, the section that was cut out of the bill, I do want to note, as many of you may already know, but I just want to make sure you do, that you do, the Department of Corrections website already gives the transparency that the gentleman was requesting. You can get on their public website and see the names, the crimes, the countries of origins of the people who self-report to be here without having been born somewhere else. So all of that is already on there. You cannot get status information, that is true, but as Mr. Arturo mentioned earlier, when the Georgia GBI reported that the federal immigration authorities have said that that information is law enforcement sensitive and so cannot be publicly released. And if gotten from the federal government and if gotten another way, then you will be asking the Department of Corrections, the Commissioner of Corrections, to use a method for posting immigration status, for determining immigration status, other than that which is set by the federal government, which obviously raises serious preemption concerns. My one other point is with regard to detention in Section 44-4-14. It was Section 4 of the bill in the version I have, but I don't think it's Section 4 anymore. It has to do with the shall detain someone who is verified to be an illegal alien. The senator mentioned that the 72-hour notice means that corrections officers will not hold anyone beyond the period authorized by law. That is perhaps true with regard to some sections, but not with regard to the change made in 42-4-14, because holding someone on an immigration status violation still runs afoul of the Fourth Amendment if the officers are not holding someone otherwise authorized. So if they're holding somebody on a sentence and the sentence hasn't run yet, that's fine. But if the person has had the charges dismissed or has posted bond or has served their sentence, the officers cannot lawfully hold the person on an immigration status violation, and that language, making it clear what the officers can and cannot do, is missing from the bill. It would be easily fixed by putting in some language such as for the period otherwise authorized by law, or to the extent the verification is accompanied by a judicial warrant giving probable cause of criminal activity. So thank you for your time and attention.
Thank you so much. We're going to take just a second. I think we've got copies of the substitute. And if Jan would pass those out. I believe that's, should have plenty there. Gloria Kalanko.
Good morning. Thank you, Mr. Chairman and members of the committee. My name is Glory Afi Kilanko. I'm the director and founder for Women Watch Africa. We're a social justice nonprofit organization working to serve the interests of refugees and immigrants in Metro Atlanta and currently serving refugees and immigrants from 23 African nations. While I commend you for all the corrections and additions that have been made on this bill, I am representing the community that I serve to say the need to even discuss SB 452 should not arise. I work in the Clarkston area, which for those of you who are familiar with Clarkston, Clarkston is known in the US as a mini United Nation because of the demographic in Clarkston. And I want to speak on behalf of the women that I serve. Immigrant women who are in these countries, we have come from war-torn countries and we have been traumatized, and people in uniform have not been known to be our friends. And I'm focusing my attention, speaking to my sister who is sitting in your midst, to say as a woman who is going through abusive situation, to not be able to have the power, the courage to go to law enforcement to say I am being abused, I'm being victimized, is going to create more uncertainty and unsafety to the community. We have worked hard to be able to encourage women to say if you are being abused, your status does not mean you should condone violence, that America is a land of opportunity and safety. America will protect you. But now, these same women that we have encouraged to speak up can no longer speak up when this kind of bill is put in place. That renders our community very, very unsafe, very, very insecure, and we should not, by any means, adopt or pass this bill. I also was happy to hear the gentleman who adopted children to talk about the impact that this will have on our children. As a mother, it breaks my heart to find out that American-born children, American citizens, would now have to suffer the separation of their families because of a bill that would have brought about correction. We as immigrants have come to this country to learn. America is a land of opportunities for us to grow. Why should we not be given the opportunity to learn rather than that being criminalized and be punished on things that we want to learn and understand how we can make amends from mistakes that have been made? Our local law enforcement are our friends in Clarkston. We know each other in Clarkston. But if this bill is put in place, we will now be afraid to even say good morning to each other when we pass around the street. So I want to appeal to your conscience. I want to appeal to each and every one of you. I want to appeal to you to put in consideration women who ran to this country for safety and their children, and let that be topmost in your hearts as you discuss this bill, and to join me in saying big no to Senate Bill 452. Thank you, Mr. Chairman.
Thank you. We have a couple of Representative Jackson.
Thank you, Mr. Chairman. To the speaker that was just speaking, just for clarity, where is Claxton?
Clarkston is in the Evans County, by DeKalb County. And
No, she's not talking about Claxton, Georgia, I don't think.
Clarkston in DeKalb County.
You said Clarkston.
Clarkston in DeKalb County. Next to Decatur.
Got you.
Up on Memorial Drive.
I thought you were talking about Claxton, Georgia, where me and Bill are down in that area, and we wanted to be clear.
I'm talking about the mini United Nations.
Thank you so much.
So we've got this all squared away. We're not talking about Claxton, Georgia, the home of Martin Neesmith Chevrolet. Mr. Glanton.
Thank you, Mr. Chairman, and I have a question for the last speaker as well. Ma'am, if you come back to the podium, please. And thank you as well for your testimony and your passion for what you advocate for. I guess I'm a little bit confused, and if you could bring some clarity to me. Are we talking about women who are abused by criminals who have committed crimes, who are most often the ones who abuse women? You talked a lot about protecting women that are being abused, but this bill is more about people who commit crimes that are unlawful in the country. And oftentimes, those atrocities are against women. So help me understand where we are in the conversation.
When I talk about women who are being abused, a woman who, an abuser is an abuser, irrespective of what country the abuser comes from.
Agreed.
But where the problem comes is the fact that if the woman is undocumented, even if she's married to an American citizen, she cannot come up to call the law enforcement because first and foremost, she's also threatened by her American citizen husband to say, if you call the law enforcement, I will tell them you are undocumented and they will deport you.
Thank you.
You're welcome.
Mr. Petrie.
And I waive. I thank my colleague.
Quick question about that, because the immigration law allows that person to file for VAWA, which is Violence Against a Woman Act. So they could go to the immigration and file that petition, and so that the immigration will see that if there is a record of the criminal record of the husband, then that wife could.
But if the interpretation of whether the officer who is adjudicating...
Excuse me just a second. Excuse me just a second. Would y'all just judge? This ain't your courtroom. So we're going to keep some kind of semblance of order before we move forward. Mr. Petrie.
Just want to appreciate the lady's comments about protecting women. I think we all want to do that. I have spent my entire time here on public safety trying to protect everybody. I don't care where they're from. But this list, to piggyback on what my colleague just asked, I mean, when you look at this list I'm looking at, sexual battery, aggravated stalking, aggravated sodomy, voluntary manslaughter, kidnapping, these are crimes against women, my friends. And yeah, we need to make sure that we're removing bad guys from this country. Let's don't lose sight of that. No, I don't think anybody up here wants to capture good folks. I know I don't. But we're trying to find balance and to make sure that we protect everybody, and that is largely what we're speaking about, and I appreciate your comments.
Mr. Glanton. Wave. All right, next up, Reverend Tom Haygood. And while he's coming up to the committee members, you're going to hear a lot of testimony from folks today. A lot of us are going to be impassioned on one side or the other of this issue. But let me remind you that when you're listening and absorbing this information, this is about doing something in the criminal justice system for those who perpetrate crimes.
Mr. Chairman, members of the committee, Mr. Chairman, I do ask, I'm sure on Sunday mornings you're not doing this to your pastor either, so bear with me, okay?
No, sir, I'm a Baptist, and I sit at the back so I can get out of there.
There you
when
go,
the time
okay.
runs out.
My name is Reverend Tom Haygood. I am a faith leader and a pastor of Columbia Presbyterian Church in Decatur. I understand all the economic and social reasons why SB 452 is such a dangerous piece of legislation to our communities. I understand it will negatively impact county budgets all over the state. I understand it will increase litigation cost. I understand it will increase the cost to our judicial system. I understand it will have a catastrophic effect on our Georgia economy. And I also understand that it will make our communities less safe. But I understand something else as well. as a faith leader, I believe much of the debate surrounding this unjust piece of legislation can be resolved by simply reading and following the word of the Lord. Someone once wrote, "The Bible is the ultimate immigration handbook." And if you think about it, that's right on the mark. Throughout the Bible, you will witness story after story from Genesis to Revelation, all marked by the movement of people from one place to another. And as we've come to realize, Georgia and this nation were built by immigrants, many of them undocumented immigrants, many who came here a long time ago. But I've often wondered how people of faith can enter into the debate about undocumented immigrants without even considering the very words that Christ spoke. "I was a stranger, and you welcomed me." Many of you representatives here today declare that you seek guidance from Scripture every day, praying for the wisdom of our Lord. This meeting began with prayer. Yet it is so baffling to me that any elected official can advocate for immigration policies that are no better than how the Egyptians treated the Hebrew slaves. It is an illogical dichotomy that policymakers can ask for the wisdom of God and then ignore what is plainly evident in Scripture. Do the words of Christ belong in the debate about SB 452? Do the words of Christ belong in the debate about a long-term legislative solution to our immigrants? As a pastor, I believe they do. In the parable of the Good Samaritan, we are the ones who are lying in the gutter. We are the ones who are hurt. We are the ones who live in fear behind locked doors, and we build walls. And the Samaritan, I would like to say, is the immigrant who comes into our lives not trying to harm us, not trying to steal from us, but reaching out to us with eyes of hope, filled with the love and grace of Jesus Christ. You see, I honestly don't believe these mothers and fathers and children who come to this country in search of a new life are the root causes of our problems that we face in Georgia and in our country. Not at all. And just maybe if we pray about it, we might begin to realize that these wonderful neighbors of ours are actually part of the solution to many of the problems we do face in this country. We just have to stop and look into those eyes to see the face of Christ standing before us. Just the other day, I met with a group of mothers, fathers, and their children whose lives today are filled with fear every time they walk out their front doors for fear of being stopped. But when I look into the faces, I don't see illegal immigrants. I see my neighbors who only long for what each one of us seeks in this world, a place to live in safety and peace, a place to raise a family in a country that used to be the most compassionate and welcoming and loving place in the world. And when I look into their eyes, I see the face of Christ looking back at me, saying, "When I was a stranger, you welcomed me." I hope and pray that if you truly are a follower of Jesus Christ, you will take time to study the issue of immigration theologically through the eyes of Scripture and discover what I believe is an important missing piece of our discussion. Thank you very much.
Thank you, Minister. And for some reason, you seem to have garnered more questions than anybody. So, Mr. Clark.
Thank you, Mr. Chairman. Being a former youth pastor, I'm quite, and having time in seminary, spent some time studying scriptures myself. And I, like you, Pastor, want to apply Scripture to all areas of my life, whether it's in politics, being a husband, being a dad. I want to view things through the lens of Christ. But I'll be honest, I don't like being spoken to condescendingly regarding Scriptures. And the reason being, if you take that story of the Good Samaritan that you just spoke of, this bill, and maybe the bill still is flawed, hearing from some testimony, maybe the bill still is flawed, and there's some issues, separation of powers, jurisdiction issues, state, federal law. I get that. But if you take that story of the Good Samaritan, what we're trying to accomplish here is dealing with felons. We're trying to deal with the robbers that left that person lying on the street, lying on the road. That's the people we're trying to deal with here. And being a good neighbor, being a good Samaritan, would be to get rid of those robbers that are punished, that left the man laying on the road to die. So that's what we're trying to accomplish. I just want to make clear, like as the chairman just noted, making clear what we're trying to accomplish. Maybe it's still flawed, but what we're trying to deal with are the robbers and the people committing crimes and hurting people. Those are the ones that we're trying to deal with. So, and to the lady who spoke previously to you, I get the fact that there's people that come here from war-torn countries, people where their government didn't respect human rights, and they're here and they're skeptical of government, and they have concerns that if you start cracking down like this, that maybe it will keep people from coming forward. So I get all the concerns, and I have the compassion of Christ, and the love of Christ should compel me, according to 1 Corinthians. That's what led me to get into politics. But to falsely use a narrative to push a policy and a politics is just as damaging as a heart hardened to the gospel. So I just want to make sure that everybody here is aware that what we just applauded for, I think we all agree. We want to treat people with human rights. I spoke with some of the people before here. That's why I got rid of the mandatory detention part of the bill, was because I wanted to treat people with human rights, because I believe in Imago Dei, that all people are created in the image of God, and all people have value, regardless of nation of origin, regardless of the color of your skin, regardless of your sexuality. You are made in the image of Christ, and therefore have human rights and should be treated therefore. And our government was established to protect human rights. And our Constitution was written to protect the rights of human beings, regardless of citizenship. So, sir, with all due respect, what we are dealing with in this bill, and the intentions and the heart behind this bill, is to deal with the robbers that left people to die on the street.
I appreciate that point, I really do. But I also say it does immense damage to those who are not the robbers.
And that's where I would say that maybe it's still flawed. We will continue to work on it.
And I would hope that possibly, if that's the case, then maybe what we need is a little more time to work something like this through the House and the Senate, and maybe look at this again at another time.
Next, Mr. Petrie.
Yes, sir. Thank you, Pastor, for preaching at us this morning. And I will tell you that I have many immigrant friends in my church that I do my best to help and care about absolutely, completely. And everything that was just said very eloquently, we are talking about criminals here today, as our chairman emphasized earlier. And so I want to mention something to you. You made some comments about us not being welcoming. I'm going to ask you a question. Is not the United States of America the most welcoming country to immigrants on planet Earth? We have 1 million legal immigrants come to America a year. Is that correct or false?
I do not know.
I
Listen,
want you
let
to
me finish
answer
my
the
ending
question.
on that. I do not know the facts and the figures
Who takes
on that
in
particular
more
thing.
immigrants per year than America?
All right.
Canada.
We can
okay.
have that
So
debate
Canada's
a lot
the
of times.
best. Okay. So, all right. So you disagree that this country is not welcoming to immigrants, and we have taken in millions of immigrants every year for
is not the
decades.
compassionate country that
Okay.
I grew up in.
Okay. All right. One last question for you.
And before you had
Okay,
another
one-
point.
no,
You
one
had
last
another
question
point
for
on
you.
your earlier statement, though. I need to respond.
No, we're not
to.
talking about my earlier statements. We're talking about a question
I'm
I have for
talking
you
about
now.
to me.
My question for you is, can you define catastrophic for me? Because you used some big, you mentioned that this bill is going to be catastrophic. Was your term
There's a
to the
little
Georgia
community.
economy? Can
There's
you
a
define
commu-
catastrophic
yeah,
in your vocabulary?
There's a community in South Georgia just a few years ago that had a factory, and it was raided by ICE. That community was catastrophically destroyed economically. I can provide you with that particular story.
I think, is
These
that
are
in
the
Stillmore, Georgia?
Yes.
I know well about that case. I know a lot of folks from that area, and they actually are doing quite well down there right now.
Well,
and actually, we have American citizens that are earning a higher wage there, and immigrants, and legal immigrants, hundreds of them, that are working in that plant, making more money today than they were
Good.
before.
Okay.
Legal immigrants from other countries that we absolutely always want to support. They're making more money than they were
But
then,
have
too.
we looked
But
at
thank
the
you for
over-
making.
Have we looked at the overall figures of what would happen if we do pass such a bill as this? It does impact more than just criminals. Greatly. Okay. Thank you,
Master,
Mr.
we
Chairman.
thank you for your comments, and you seem to have, are you sure you're a Presbyterian?
Oh, I'm very Presbyterian, sir.
You seem to be able to draw some of the ire of Southern Baptists.
Sometimes I do.
So,
But I work with a lot of fine Southern Baptists, trust me. Okay, thank you.
Congratulations, Reverend. If I might remind folks in here that we're trying to stay on focus, and regardless of what you may hear, we do need to keep order in the room. So if y'all would be respectful of that. And also, I've heard a couple of comments about legislation being immoral or whatever. Let me tell you, this is a legislative process, and every elected member has got a right to put in a bill. And those bills, for the biggest part, are never immoral. It's only a starting point to find solutions to the problems that we have. And as I had stated a while ago, this bill is not best of my looking. This bill has nothing to do with trying to penalize or to be punitive to anybody except criminals so that they can be dispatched properly. That being said, Mr. King?
Good morning, Mr. Chairman, members of the committee. My name is D.A. King. I am president of the Dustin Inman Society, an organization that is nonprofit under the IRS that we formed in 2005. The Dustin Inman Society is named after a Woodstock, Georgia American citizen who is forever 16 years old because we do not enforce our immigration laws. I have stood right here in this very room in 2006 and other years to get state laws passed that address the illegal immigration problem. In Georgia, we have more illegal aliens than does the state of Arizona. I hope that I can hit all my points, and I'm doing it as quickly as possible, but from the top, what I heard from the subcommittee chair was that we don't want to be like Nazi Germany and require people to carry a visa. So if I may be indulged for 10 seconds to read part of the Immigration Nationality Act that was passed in the year 1940 before we began our war against the Nazis, as my family did. Every alien 18 years of age and over shall at all times carry with him and have in his personal possession any certificate of alien registration or alien registration receipt card issued to him pursuant to this section. I have watched Americans and heard about Americans being killed, losing their loved ones, having their families separated in the name of justice. When we import immigrants from all over the world every year, Representative Petrie was correct, 1 million a year, plus guest workers. It is impossible for me to accept that we can honor a rich tradition of immigration if we are not willing to step forward and be brave enough to fight the vastly funded illegal alien lobby that you see in front of you today and stand up for what is right and just for American citizens and the rule of law. The Nazi Germany thing was a little bit over the top, State Representative. The estimate in 2010 was that this state spent from taxpayer money about $2.5 billion a year on the crime of illegal immigration. I don't know how much it will cost to sharpen our enforcement efforts, but for my money, and I assure you, for the law-abiding Americans who are home watching on TV or their computer, there isn't a way to go too much or too high. I wanted to address, if I may, Mr. Chairman, something that Representative Petrie said. We are constantly told that illegal immigration is a blessing and we can't live without it. I think that Georgians have a great interest in what we're paying for that and have it quantified as far as our Department of Corrections. I had a conversation with the Sheriff's Association lobbyist, and I know that they had a problem with that. I also know the Department of Corrections did not have a problem with that. Taking out the quantification part of the language of the rule, language of the bill that would require DOC to at least report every 3 months the number of non-citizens and the number of those who law enforcement has determined through federal tools to be in this country illegally, and report that to the public every 3 months for a couple of years, we could have a very good idea of what at least incarceration is costing us for illegal immigration. The Law Enforcement Immigration and Customs Enforcement Law Enforcement Support Center is designed to be a central point to disseminate, sure enough, immigration status to law enforcement. And I wanted to agree with Judges Jacobs and Lopez. I stood at this exact podium in this exact room in 2006 when we passed the first comprehensive illegal immigration law in the country before Arizona. It was Senate Bill 529, and there is indeed on the books language that requires law enforcement to, at best they can, discern the home country and the immigration status of people checked into jails. It needs to be sharpened. As far as I'm concerned, respectfully, before I sit back down, the subcommittee has gutted what is a very good bill, and I wanted to thank Senator Stone for introducing it. I hope that you will put back at least the Department of Corrections amendment that I think Mr. Petrie is going to offer. I could stand up here all day, but please know that what you see in front of you is what we call the anti-enforcement illegal immigration lobby. And there's more money on that side than there is on the pro-enforcement side, but I assure you there's more Georgians on the side of right, justice, and enforcement than there are in this room. I'm more than happy to take any questions.
Any questions? Thank you, Mr. Ging.
Thank you, sir.
Stephanie Ali.
Hi, everyone. My name is Stephanie Ali with the Coalition of Refugee Service Agencies. We're an 18-member coalition of organizations that serve all immigrants from all different walks of life and backgrounds. And I do want to take a moment to thank Representative Clark. I know you were kind enough to meet with some of our representatives on Thursday when we were here and talk through your thoughts on working on the sub. And we really respect you for taking that time to meet with us. So thank you. We know you worked hard on this, and to everyone else for allowing us the testimony today. I do want to just push back a little bit on the original intent of the bill altogether. Like Ms. Glory, we work directly in the city of Clarkston a great deal. I additionally am the daughter of a chief of police who served my entire life in that role and led the most dangerous aspects of that work. He was a SWAT team captain, bomb squad captain, and one of my proudest moments was when Alabama passed a similar law to HB 87 in his version. His reaction was that he wasn't going to enforce it. My dad had always been hardline immigration, but he said, no one tells me who to put in my jail except for my deputies. He knew what was best for his community. He believed in community policing. And in the 6 years I've worked in Clarkston alongside our community members, I've seen the same thing from Clarkston Police and from DeKalb County Police, where I'm happy to live. They believe very much in community policing, and the fact that what's best for the community is to have police that they trust, to have sheriffs that they trust, that, like Ms. Glory pointed out, where they will come to report crimes, whether they're the victims or someone else is the victims. Yes, we absolutely need to take people who are dangerous off the street no matter what their background is, but we need to understand that our local law enforcement are the first responders to that, and they're the ones who are going to know best how to interact with their police. So I want to push back on what Senator Stone said was the original intent for this bill is because we have sanctuary cities are non-cooperative local jurisdictions. Sanctuary cities have been illegal in Georgia since 2010. We don't have any here. We have places who have decided to be non-detainment locations. Their lawyers have worked closely, including in Clarkston last April and in Decatur shortly following that, to follow the letter of the law. They're not sanctuary, they're non-detainment, and in fact, anyone who's picked up wouldn't even be in jail in those locations. They'd go to the DeKalb County Jail instead of in Decatur and Clarkston because they don't have jail. But it makes their citizens feel safer and more likely to work with them. And so instead, make sure I say this correctly. They do still work with ICE. We were involved in those discussions when they were looking at being in non-detainment. They still work with ICE if ICE gives them a judicially signed warrant. If there is a warrant from ICE saying that we know that we need this person and a judge, like our trusted members of the judicial branch who are here, has signed off on that. So there is immigration law that is being enforced here in Georgia by our trusted member of law enforcement. They are doing what is best for their local communities on that level and following through with federal enforcement as long as that's been shown to be someone who really truly does need to be picked up, not just someone that they're holding without reason. So I just wanted to point that out to you guys, being someone who works closely in Clarkston, that the original intent of this bill may not be accurate for any reason. And while I do respect all of the changes, and I thank you very much, I think that's taken a lot of the pressure that that local enforcement were concerned about that I've discussed with them. It doesn't fix all of the issues. So yeah, I thank you very much for that time. And I look forward to you guys voting against even the new version of 452.
Thank you so much. Any questions? If not, I would like to ask one, what's the difference between non-detainment and sanctuary?
Yeah, I just learned this year too, when everybody was trying to be careful. So the non-detainment, there are a few locations in Georgia that do this. Sanctuary would basically mean, and in Georgia, as you guys are probably aware, last year they passed a bill that would also mean campuses can no longer be sanctuaries. So really it's only up to churches now. But sanctuary would mean everyone could come in there no matter about their status, wouldn't be asked of their status. Even if ICE had detainment, they wouldn't pass them over. They wouldn't work with ICE at all. Non-detainment just means that they won't be held in awaiting ICE custody, so that we wouldn't hold them for that 48 hours to turn them over unless, as is the letter of the law, there is a judicially signed warrant. So someone wouldn't hold them, so a local municipality wouldn't hold them in just to wait on ICE because ICE has requested them. And if you're interested, some of our partners here do have a list of non-detainer policies in the state of Georgia that I can give you, Chairman. So you'd be able to see which localities, municipalities have already decided that rules like this are not helpful in their jurisdictions, that they know this doesn't work for them. I'd be happy to give that to the committee.
Thank you, ma'am.
Yeah.
Mr. Chairman, may I have permission, 10 seconds, to add something to my testimony? 10 seconds.
If you would like to, I know a lot of my friends would also like to do that.
I'm almost afraid to say yes because it'll open up the discussion again.
I won't stand up and speak from the floor like they do. I just wanted 10 seconds of the microphone.
Let's move on. Thank you, though. Ed Painter.
Mr. Chairman, thank you and the committee for having such patience with all of us who want to make comments about this. I'm Ed Painter. I'm from Dalton, and like some of the others in here, it cost me to come down here, but I felt the necessity to talk about this bill from my point of view. And as far as why we should have a shall instead of a may, the young lady just provided an example of that, good examples. It should be shall. I want to give a few minutes about my history, where I'm coming from, because we all have preconceived notions of the person standing up here. My family on both sides in Whitfield County go back and predate the Civil War. So I'm about as white Southern as you can get. My wife, however, I married her in 1969 in Korea. She immigrated that country. We're still married, and she became a U.S. citizen in 1976. At that time, it took 7 years. I also sponsored one of her sisters. She has two sisters. Both of them live in Colorado. The one I sponsored just retired from United Airlines. Her brother lives in Hawaii. My son-in-law is an immigrant from Chile. When he married my daughter, I insisted he get his American citizenship, which he did. He didn't want to do so because the laws in Chile would have made it difficult for him to help when he went down there, to help his family should there be any trouble. His sister, who also helped get her citizenship, lives in Dalton. All of them consider themselves Americans first. And if they were not encouraging me in this endeavor as far as talking about illegal immigration, I wouldn't be here. I wouldn't be able to stay at home. So I wanted to share with y'all that part of it. I was a sworn-in certified deputy in Whitfield County for 23 years. So Whitfield County is a 287G county, so I'm a little bit familiar with that. And one of the things I want to say, if my wife or my son-in-law get pulled over, they'll have a real ID driver's license. So there's not a lot of checking on some people when they have the proper identification to begin with. Now, as far as costs go, I hear a lot of people talking about costs, especially the judges, et cetera. Well, in Whitfield County, we now have almost 70% of Dalton Public Schools Hispanic. Over 65% in Whitfield County Public Schools. A few years ago, we built a new county high school. We just approved a $50 million bond for the city to build another high school, or another school. It's not a high school. So I do visit the emergency room. My daughter was in the maternity ward 3 times. I know what the cost of illegal aliens has been. Although many of them are now legal, of course. I have 3 grandchildren that are in the Dalton Public School systems, so I'm very familiar that most of them are legal aliens because a lot of them were born here. However, we are still providing incentives for more illegal aliens to come. Many of the arguments I heard boil down to the fact we should just have open borders. I don't believe in that. I know the impact of having a flood of I won't say immigrants that do not assimilate into our community. Too many, too quick. So that's why I am definitely for this bill, including the misdemeanors, including the shall. And as far as me personally, how I look at illegal aliens personally, around 1990, I helped someone that was working at our plant become legal, go get his family. He's from Mexico. How I act on a personal basis has nothing to do as far as what I see as responsibility of Georgia or the legislature to make Georgia as unattractive as possible to illegal aliens. And if there are any questions, I'll be glad to answer them.
See no questions. Thank you, Mr.
Thank you, sir.
Megan Gordon.
Hi. First I want to start by thanking y'all because we've been here a long time and y'all have heard from a lot of people. So thanks. Thanks for sticking with us. Thanks for still being here. Thanks for allowing all this time and this very, very busy last few weeks of the session. I really do appreciate it. My name is Megan Gordon. I work at the Feminist Women's Health Center, and I also have previous experience helping survivors of domestic violence get temporary protective orders against their abusers, which gives me the insight that I wanted to share with y'all right now. I'm going to be brief because I know that some folks have already spoken to how this will impact domestic violence survivors, and I know that some of y'all have concerns about how relevant those concerns are to this bill, so I'm going to ask you to bear with me. I will get to those concerns, and I'm going to breeze through the sort of barriers part real quick, just to create some context. So, all survivors of domestic violence face barriers to getting out of that relationship. The psychological aspects of realizing they're in a cycle of violence, making the decision to leave, logistical issues like community support or judgment or lack thereof, getting attorneys, custody, divorce, housing, all of that stuff. Everyone, no matter race, language, immigration status, deals with all of those, and that on its own is a lot for a lot of people. Immigrants face an additional layer of barriers regardless of their immigration status. As Glory so eloquently reminded us earlier, a lot of immigrants come to this country because they are fleeing governments where the police were not there to protect anyone. And so for those folks, the simple act of reporting crimes against them to law enforcement is already terrifying and takes a lot of courage. And then of course you have language barriers, etc. For undocumented people, there is an additional layer on top of all of that already, which is fear of their own deportation, fear of children being deported, and then even for people who might be citizens themselves, but for whom their abuser is undocumented. I have seen cases where survivors were hesitant to report that person because they wanted to be safe. They wanted this person away from them, but they also hesitated to separate children from their father, no matter how abusive that father was. If their abuser is getting deported, they're likely never to see their children again, right? And that's a really big move and a really big separation for a survivor to impose upon their family, and a lot of people really hesitate to do that, no matter what sort of violence they're going through. Okay. So you've heard all of this before, and some folks have heard concerns that this isn't really relevant to the bill. So I appreciate that y'all want to deport bad guys. I appreciate that deporting people who are hurting other people seems logical and can protect survivors of violence. However, that only works if the victims are reporting their crimes to law enforcement in the first place. And that is my concern with how this will impact survivors of domestic violence. I think that if this bill is passed, undocumented survivors or those who are being abused by people who are undocumented are not going to report in the first place, which is counterproductive to the goal that y'all are trying to achieve. Secondly, I acknowledge that because of the way the substitute has been changed, we no longer have the concerns that I shared with the Senate committee that the victims would be caught up and deported before anyone could really realize they're victims. I could get into that if y'all want, but sometimes when law enforcement arrives to a scene of domestic violence, it's not clear who's who and what's going on, but I digress. If this bill is not going to harm victims of crimes, they are not likely to know that. Y'all probably have all experienced folks talking to you about bills and not being totally aware of what exactly those bills do. I know I, in my work, spend a lot of time explaining the nuances of bills to people who don't quite understand them. And I don't think that the simple existence of this bill isn't, folks are just going to hear someone went to court and got deported. They're going to know they're not going to know it was a felony. They're not going to know who else is included. And so they're just not going to report crimes because they're not going to be aware of everything, all the details of this bill. Thanks, y'all.
Thank you, ma'am. Oh, thank goodness. Last but not least, probably the nicest message on here, Bernice Rodriguez says she may or may not speak. But I guess you've decided to speak. Welcome.
Should I shawl or not speak? But I will. Again, my name is Berenice Rodriguez. It has an E in it, but that's okay. I'm with Asian Americans Advancing Justice, and I work in their policy department. I know some people here asked about numbers specifically. I do want to throw it out. It would cost $32 billion to identify, arrest, and detain and remove undocumented immigrants, regardless if they committed a misdemeanor or a felony. This is exactly, in 2011, when HB 87 was introduced, I was a freshman in high school. I am now done with college, and I'm back again with the same similar kind of bill that HB 87 tried to do. And going off of that, I don't have a problem with transparency. I really don't. I think the bad guys, as you guys call them, or the criminals, they do need to be removed from the country they were, regardless of their citizenship status. But I do think that it's unfair that all of a sudden, even legal citizens who may look Latino or Hispanic or like an immigrant be racially profiled and stereotyped, and then their life would become a little bit more difficult. I have plenty of friends who are U.S. citizens and family who are also U.S. citizens, and I don't think it's fair for them to live in fear because they look a certain way. So I do think that this bill is a little bit flawed. Well, it's very flawed, but I think that some of the changes did address that, but I really don't want it to become something like the 287G program that happened, where a lot of these counties targeted specifically certain communities, and I don't think that's fair. I think that needs to be a little bit thought out. I agree with transparency, but I also don't want to target people who are not supposed to be targeted in the first place by accident. I also want to point out, I've been doing a lot of work in South Georgia since I was 14. I'm now 24. So I've been going to South Georgia every summer to do a lot of work around immigrant farm workers, a lot of them on the H-2A program, so a lot of them are legally here, and a lot of them aren't. And I think that's something that a lot of people up here tend to forget about, that community and that population. I remember 2011 when HB 87 was introduced, I talked to a lot of farm workers and farm owners who said they lost millions just because a lot of migrant farm workers were skipping the state of Georgia. And I really don't want that to happen again because I love Georgia, and I think that that could be very detrimental to our economy, and I don't want that to happen again with certain laws like this one. That's all I have to say.
Thank you so much. And we have.
Also, I'm sorry, I think you're clicking my part. I'm Gail Schwartz. 2 minutes if you still have some time.
You didn't sign up, you sent your card up here, is that correct? Do you think you can stay within a 1 minute time frame?
I don't know, just maybe 2. Can we negotiate?
Can you stay within 2 minutes?
I'll try.
All right, we have questions. Mr. Glanton.
Thank you, Mr. Chairman. Before the next speaker, I had a question of the previous speaker.
Sure. Ms. Rodriguez.
Berenice, thank you.
Mr. Rodriguez, I just want to get some clarity here, just so we can have accurate information here on the committee. You used the number 32 billion, is that correct?
Mm-hmm.
And you said in reference to the 32 billion, it would take to deport, whether we're talking felony or misdemeanor. Are you suggesting that there's that many criminals out there that are undocumented that it would cost us 32 billion? Excuse me, Mr. Sir. I'm actually speaking to the last speaker. Okay. Are you suggesting that it would take $32 billion to deport criminals, whether felony or misdemeanor, for undocumented workers?
Not only to deport, but to identify, arrest, detain, and remove. That includes all the added personnel to the unfunded police departments and local police enforcement.
Follow up, Mr. Chairman. How did you come to that figure? How did you come to 32 billion?
So
what's the statistics? What's the data that supports that number?
Yeah. So we provided a packet with policy briefs and info with statistics on very specific places where we received that data. You should have that packet. If you want to refer to it specifically, it's under the Asian Americans Advancing Justice policy brief, and all of the statistics are clearly stated. That was just one that I stated up here, but there's much more, and it tells you how we came to that conclusion.
So we're not talking about, Mr. Chairman, follow up. So we're not talking about overall undocumented workers. We're specifically talking about those who have committed crimes, whether those crimes be felonies or misdemeanors. Okay, thank you so much.
Thank you. Ms. Taylor?
Thank you, Mr. Chairman. This is more of a comment, and I probably should have waited till after the last speaker. Somehow, things have gotten turned around with what we're talking about in this bill. Georgia is a very welcoming state. It always has been. That has not changed. We have new people living here, illegal aliens, new people that come and are legal. It appears to me that we need to do a better job in schooling them about what America means. There should not be someone afraid to go to law enforcement. If you came from another country and that's the way your country was, the first thing you should learn is that you are in America. You don't fear law enforcement. They need to be taught that. That's something we have heard over and over again. Whether it be, no one's perfect, I understand that, there will be unusual circumstances, but somebody's not doing their job to assure the new people that are here. And I come from an immigrant family. Everyone here came from somewheres. Both of my daughter-in-laws are first-generation Americans. We have seen that. I grew up in Florida, in Miami. So I know and understand immigration. What we're seeing now and what we're talking about are those committing crimes. If we need to teach new people to be citizens and understand how our justice system works, then it's sorry on us for not having done it. But we need to make sure that all people in this country are able to be safe. That's what this bill is about. Thank you, Mr. Chairman.
Thank you. 2 minutes.
Thank you, Mr. Chairman. Thank you for allowing me to come in late. My name is Dale Schwartz. I live in Atlanta, and for nearly 50 years I've practiced law in the state of Georgia, including a stint in the governor's office across the street and with the attorney general next door. I'm here today to speak on behalf of the Anti-Defamation League of the United States, which is one of the oldest and largest civil rights and human rights organizations in this country, and also on behalf of the American Immigration Lawyers Association, which I had some 15,000 lawyers I've had the honor of serving president of. I believe every single person that spoke here today on behalf of an organization was from a nonprofit organization, and regardless of what you heard, they are not well-funded people. They are living off the charity of their neighbors. I also had the privilege of serving on the board of directors of an organization called HIAS, H-I-A-S, in New York for some 35 years, and the last 3 years as chairman of that organization. It's the oldest 137-year-old refugee resettlement organization. We brought a lot of those people who are in Clarkston to Clarkston. I want to say, and I hadn't prepared to say this, but I want to mention something about transparency, sir. I think if I challenge you to call the Department of Corrections this afternoon and ask them, every single person on your list already has a detainer on them. You don't need this bill for that. I have represented hundreds of aliens in little jails for anything from stealing a chicken to, speeding, and only to advise them, don't bother to put up the $5,000 bond the sheriff set on you or the chief of police set on you, because you have an immigration detainer. The local policeman that arrested you, his sergeant, his captain, his police chief, the deputy sheriff or the sheriff, they have a number. They call immigration 10 times a day and report these people. In my practice, I often come across people who have been the victims of rape, spouse abuse, and other crimes, who are afraid to go to the police and report those crimes because someone in their family, maybe even themselves, is here as an undocumented worker. This House passed laws in Georgia several years ago. My organizations and I wrote the briefs in those cases and helped argue them in Arizona, Alabama, Georgia, and South Carolina. Federal judges declared those laws unconstitutional on the basis that only Congress can regulate the immigration laws. I think that some of what you're trying to do today is for a worthy cause, but I think that you're going to have a lot of trouble, and I've taught at Emory Law School for 25 years, immigration law and constitutional law. We don't have time to go into all those details today, but I think there's some serious issues with all of those things. Thank you for what you're doing. Please consider it carefully.
Thank you, Mr. Schwartz.
Any questions?
Any questions? Any questions? Thank you. All right. At this point, I want to ask the committee, do y'all want to take a lunch break and come back if you promise you'll immediately come back?
Yes.
Immediate would mean at this point 1:45. That would give you about 35 minutes.
What time?
I understand. We do. All right. This meeting, we're going to stand in recess until 1:45. And at that time, be prepared to start doing business. We call this meeting back to order. If it's any of the folks that are out in the hallway, if you want to tell them to come on back in. I know they were salivating at the process this morning. Since most of them are university folks, I don't know if they've ever seen that process. All righty. I was asked a while ago that there's supposedly another sheet that had some sign-ups on it. Does anybody have another sheet out there that's floating around? Well, Rishi, I think y'all were the one that brought that to my attention.
Chairman, and thank you, members of the committee. I'll be really brief. Rushi Patel with the Georgia Municipal Association. We appreciate all the work the committee has put into this substitute, and we believe it addresses our major concerns. So thank you to the Vice Chairman. It addresses our major concerns about unfunded mandates. GMA did not and has not taken a position on the overarching policy goals of this legislation. We just had concerns about the unfunded mandates as it stood when it passed over from the Senate. We would insist on indemnification of those costs of the unfunded mandates if unfunded mandates reappeared in the bill, but as it is, we believe that this bill meets the policy goals of this legislature and addresses our concerns about local government costs and budgets. And with that, I'd conclude my remarks. Thank you.
Any questions from any of the committee members? Mr. King, if you'd like to stand, you said 10 seconds.
Mr. Chairman, the language that was removed that would have enabled law enforcement to forward on information of all illegal aliens apprehended or confined for any crime, and then it was changed to felonies, should be reversed. Somebody's going to get killed sooner or later, as I do almost every week, and I am begging you to erase the felonies only language and make it so that we can become aware of all crime by all illegal aliens, because it will accumulate. And I assure you, sooner or later, somebody is going to die because we didn't pay attention to minor crimes.
Thank you, sir. I know from where you speak, and I hope you've had a chance to talk to the committee members one-on-one. Now, is there anyone else that wishes to be heard on Senate Bill 451? Good. At that point, this is up to the rest of the committee, and the chair will stand for motions at this point. You are recognized. By the subcommittee substitute. We have a motion and we have a second. Now, open for discussion. Any discussion from any of the committee members?
I'd like to make an amendment, Mr. Chairman.
At the proper time, and this is the proper time.
Yes, sir.
What's your number? What's your number there? 18, 19?
19, Chairman. I'd like to amend the committee, the substitute to SB 452 by adding language that was removed that states as follows. And Julius, you have this right here. I'll hand it to you.
If you would, please state the line. And you're dealing you're dealing from LC 41 1566 ERS. Is that correct?
I am adding an amendment to LC 41 1566 ERS. The language I'm speaking from is on a previous version. That language states, the commissioner shall, the commissioner being the Commissioner of Corrections, who has supported this. On the previous version, it was line number 90. It was a section 3 that was removed.
If you would, just go ahead and make your motion, and let council fit it in.
Okay? I move that we adopt section 3 here. If I don't need to read it, I'll leave that to Julius. Or do you want me to read it, Chairman?
If you want to read it, go right ahead.
All right. The Commissioner shall, on the official website used by the Department, publish a report on the immigration status and home countries of inmates who are not United States citizens and who are confined under the authority of the Department, and the percentage of the total population in confinement composed of persons who are not citizens of the United States. Such report shall be first published on October 1, 2018, and every 90 days thereafter, provided, however, that if the 90th day falls on a state holiday or Saturday or Sunday, then such publication shall occur by the next business day.
All right. We have a motion. Did we have a second on that motion?
Second.
A motion and a second. Any discussion from any of the committee members? Any questions, comments, concerns, or otherwise? All right. All in favor say aye.
Aye.
Opposed?
No.
All in favor raise your hand. 4, 6, 7. Opposed? And the ayes have it. Any other motions? Mr. Holcomb.
Move to amend line 80 to strike misdemeanor or ordinance as the judges recommended, so it's consistent with the rest of the bill. So you strike misdemeanor, comma, or ordinance violation from line 80 of the substitute.
We have a motion. Do we have a second? Second. We have a motion and a second. Any discussion?
Mr. Chairman, I'd like to make sure I understand the motion. Could you explain, my good friend, explain exactly what
Sure.
you said again?
If you were here for the judge's testimony, they asked for this to be updated to reflect consistency with the rest of the bill. So the rest of the bill has misdemeanor and ordinance violations deleted, so this would make it consistent by striking those categories from the bill.
Gotcha. Thank you. I understand.
You're welcome.
Any further questions on the motion? All in favor say aye.
Aye.
Opposed?
No.
Well, I don't believe I need a show of hands on that then. So the ayes have that one. Any further amendments? Any other motions? No?
I have another amendment. Mr. Chairman, on line 19, I move that we strike from the substitute the word may and replace it with shall at that one location.
We have a motion. Do we have a second? We have a motion and a second. Questions? Mr. Clark.
Just want the committee members to know and be aware that there would be some unintended consequences. I get the reasoning, there would be some unintended consequences regarding international businesses that we have a lot of in this country and in this state, and when their CEOs that are here, it would have some negative effects there potentially. So unintended consequences, I understand the reasoning, but I think there's some potential unintended consequences that we need to leave it as a may.
May have some other problems with that. I'm going to call on our legislative council. There's concerns about possibly constitutionality of that. If you would, Julius, please explain.
I guess here, if you change the may to shall, then you're statutorily requiring a police officer to detain someone, where constitutionally they have to have probable cause in order to do so. So by putting a shall there, you likely will trigger a constitutional issue with that.
Very good. Thank you, sir.
Mr. Chairman.
Yes, sir.
May I address the committee? There is a recent decision from the Fifth Circuit Court of Appeals in the city of El Cenizo, Texas versus Texas, doesn't have a citation. It just came out March 13th of this year, upholding mandatory reporting. That their law is similar in many respects to this one.
Thank you, Senator. All right, we have a voice of motion with some discussion. Is there any other discussion on this? All right, then all in favor say aye. Aye. Opposed? No. With ayes, raise your hand. 1, 2, 3, 4, 5. Opposed? And it fails. All right, any further motions? Any further motions from any of the committee members? Any discussion? Any comments? So before you, you have an amended version as a committee substitute. All in favor say aye. Aye. Opposed? I think the ayes clearly have that one. Thank you so much. Thank y'all for being in attendance, Senator, and this will be forwarded on to the House Rules Committee.
Thank you very much.
All right. All right, if the committee members bear with us, thank you, Senator. All right. Thank you, Terry. We have another bill. We have a couple of other issues in front of us. Is this the last substitute?
Yes, that's what I did for you.
That's right. We hadn't gone back to 2,500 yet on that stuff.
No, we have no. That one's still at 1,000. Now I did an amendment that boosted it up to 1,500.
Let's see, what one do we really want to deal with here? This is one that had the language about asking permission and we'll strike that too.
Right. The amendment I just strikes that and it just has that 1,500 and that they can't stop for traffic.
All right, but now we don't, in this one, it struck out the language where we were at, saying that they had to get permission from the governing authority.
No, that's still in.
That's still in.
Yeah, that's.
Let me ask you a question. Are we better off going with the original and make changes or the substitute? So we're going to probably go back to the 2,500 feet. What's easiest now?
I guess everything, all of the amendments are based upon this one, based upon 1560. But if you want to go back to the original, I can work with that too.
All right. Let's see. All right, ladies and gentlemen, we have before us Senate Bill 348. This has been this bill has created a certain level of interest. Even though I'll have to tell you, while we had to take a lunch break, I do know that the university system has brought in lunch, including famous University of Georgia strawberry ice cream cake, to certain senators' quarters over at the Capitol. And so sorry that they Committee members, you have before you the Senate bill as passed, which is SB 348FA, and we have a substitute. Now, quite frankly, this substitute is probably not even going to look the way it looks when we finish. If I might make a few comments, Senator Harper asked me would I fill in for him today, and that's what I'm going to make an attempt to do. The underlayment of this bill, quite frankly, all it did when introduced, it gave the tech schools the authority to have a police department. There were changes made over in the Senate that dealt with the yardage and the footage of how far off of the campuses that these schools have jurisdiction. because of circumstances and events, it brought into a lot of debate, a lot of possibilities, and as I've been noted to say, we killed a lot of pine trees and used a lot of ink, and a lot of that's probably for naught at the end of the day. We do have some folks that that signed up to testify on this. I guess we might as well get to it. I don't think the tech schools need to say much because I think I've already said what they needed to hear. Representative Tankersley, do you want to be heard or you want to sort of hold off?
I would like to hold off.
All right. Ashley Jones and Rolling Downs. Which one is Batman and which one's Robin today?
Robin Downs with the University System, and Mr. Chairman, thank you for last night letting us come see you and talk about some of the unintended consequences that we felt came out of the Senate vote. And so we do feel like Amendment 41-0366 really does strike the right balance here. So we appreciate you hearing us out and all the people as well. We talked quite a few of you about the
Which, would you repeat that substitute?
the amendment that I got from him is AM 410366.
No. We don't have that one.
No, we got it, and I didn't put it in the folder until now.
Do we have enough copies? Yeah.
What color was that bus?
I must have been under the influence of House Bill 452 this morning.
I testify on her behalf. I heard you say that.
All right.
Pass with
And now this is what I was talking about. We killed a lot of pine trees. All right. AM 410366. All right. All right. Very good. All right, committee members, if y'all will take a look at that. If y'all want to go ahead and speak, y'all got anything else y'all want to address?
The change here, and this gets us back to the 1,500 foot buffer zone in and around our campus that we think is very important. And also, it gives us the ability to address those moving traffic violations that are occurring within our campus boundaries that we discussed last night. So we appreciate you making that change for us based on the substitute that we saw. So,
Very good.
all in all, we feel comfortable with this language and we support it. So we appreciate you guys making the changes.
Very good. Any of the members of the committee wishes to ask any questions? All right.
I just wanted to point one, our legal team found a clerical error on line 35. I believe that's supposed to say technical college system instead of university system. Julie is after security personnel of the, and we just wanted to point that out.
Thank you so much. All right. Let's see, next up, Neil, you seem to be the only one, so you're gonna take a pass? You feel like you're gonna roll the dice and take your best shot at it right now, huh? Very good. All right, committee members.
Do you want me to speak to the amendment or not? Basically, what we'd like to just re-emphasize is the importance of the underlying bill. Currently, we do not have the ability to enter into mutual aid agreements with local law enforcement, and we don't have the ability to have jurisdiction on all of our TCSG property. So this will enable us to more efficiently use our police resources as well as help the local community and be good partners there. We are not part of the feet yards fight. We'll say, though, without the underlying bill, there can be no changes to that. So we'll respect the will of the committee, what it decides in terms of amendments or not. But would like to re-emphasize the importance of the underlying bill.
Thank you, Neil. We appreciate it. If I might, probably need to address a little bit of the reason for so much debate on this and issues of the last few weeks on this bill. They've been concerned by a lot of us, by a lot of the members that's been around for a while, about campus police authorities being a pretty good piece off of their boundaries as to where they were running traffic patrol at some of the other schools in the state. And I think that has probably been corrected. I think, as I understood from the regent, or from Mr. Wrigley, that a lot of this is being worked out. I think the message has been sent, the shot over the bow, per se. There is a lot of difference between our two post-secondary educational systems. One is that the tech schools generally don't have off-campus housing associated to them, and the universities do. We have a situation where campus police are being depended on to provide security for off-premise housing, quite frankly. Georgia Tech predominantly, they have no faith in the City of Atlanta PD to patrol, and some of the other schools around. So we're back to the posture. And if I might ask, if the committee's had time to look at the substitute, and I'll call for a question to see what's the wishes of the committee. Mr. Jaspers.
Thank you, Mr. Chairman. I have two amendments I'd like to bring
first
up.
off, I need to get a motion.
Oh.
If that's the wishes of the committee.
Go ahead, excuse me.
If I may. So this amendment here brings us back into 1,500 foot.
Correct.
It limits the ability for campus police to do the citations and moving traffic violations.
Outside of that 1,500.
Mr. Chairman, just a question.
Yes, sir.
Just want to be clear, along with Jay, his comment. So we're back at the same distance, and in terms of providing security to off-campus, we're back where we are today. Is that correct? The real change here is as it relates to moving violations on roadways. But in terms of, because to me it was important that we, at a time like today, the more security on campuses, the better. And so that hasn't changed here in terms of providing security to outlying areas adjacent to the campus up to 500 yards, but we have changed the ability to provide to cite people for traffic violations. Okay, that's your understanding as well? In the amendment, I'm speaking to the amendment. Thank you.
Outside,
Thank you.
outside the 15.
Outside, yes, sir. Thank you. I just want to make sure I understood the amendment well.
All right, Chairman Jaspers. At this time, let me.
We need to make a motion?
16.
Oh, we've got a question. Excuse me.
Yes, sir, Mr. Glanton.
All right, thank you, Mr. Chairman. Just from my understanding, it covers that jurisdiction within the 1,500 feet, and as far as citations are concerned, as my understanding is, if it originated on campus, is that correct? Okay, so it's just not the 1,500 feet buffer for those citations for them to chase them or go after them or apprehend them. It would have to be something that originated on the campus or property of the campus.
It gets outside of the campus roadways definition, that's correct. Yeah.
Thank you.
Yes. Chairman Lunston.
I move that we do pass on Senate Bill 348 as amended by AM 410366.
We have a motion. Do we have a second? We have a second. Now we're in the posture. Any subsequent motions from any of the committee members?
Thank you, Mr. Chairman. Committee members, in your package, you'll see two amendments I have. I'm only going to use one of them, and I've got another one that Julius is going to help me with. If you look at one, it's AM 410363.
Do not have them.
Should be. Oh,
We got 660.
yeah, that was supposed to be in the folders. Yeah, I thought it did. Well, okay, we're gonna go print this one. I got another we can do.
Tell you what, while we're getting the
Yeah,
copies
no,
on
it's
this,
perfect.
we'll suspend action on this, and we'll move to Ms. Carter's resolution. We can whack that out while we're getting copies made.
Okay.
All right. If I can find that. Yeah. All right. House Resolution 1416, Representative Carter. The committee heard this bill last week. This was one calling for a study committee on bail bonding and such. And it was a little bit, a lot of puffery on the whereases, so we didn't want to taint that so much. So if you would, Chairman Jasper.
Yes, sir. If you look on, you've got one of those, I hope.
No.
Yeah.
Yeah, it's at the very back.
Very back.
Very back in mine. What is it?
It's
Resolution
Resolution 1416. Should be on the very last thing. Okay, during the testimony, we heard this last week. There's quite a number of questions of data and some policy implications, and we thought if this is coming from this committee, we'd simplify it and clarify it. And what I did under the chairman's direction, did just that. So just kind of go with me down through there. I'm going to say we're okay with something, and we struck something. So it'll make it easier for you. Lines 2, 3, and 4, okay. 5 and 6, okay. Striking 7 and 8. Okay on 9 and 10. Okay on I didn't do that. Strike 11 and 12. Strike 13, 14, 15, 16, 17, 18, 19, and add. Whereas the House of Representatives finds that there is a need to analyze the available data about the jail population in Georgia, specifically about those who are being held pre-trial for nonviolent misdemeanor offenses. And so that really gets down to the nitty-gritty of what Representative was looking for, just to really look at what's going on in the state.
Major. This would be much more. What was that language you added at the end?
Okay, read again. So this would be whatever line it would end up being. Whereas the House of Representatives finds that there is a need to analyze the available data about the jail population in Georgia, specifically about those who are being held in pre-trial for nonviolent misdemeanor offenses.
Excellent.
All right, any questions? Number 15, Mr. Cook.
Thank you, Mr. Chairman.
Good to see you being heard from.
Yes, sir. Thank you very much. I'll have to screenshot that and let my wife listen back to that later. Chairman Jaspers, if I could, just a question about this resolution, the changes you made. Couldn't we just get that data without having to do a study committee? And spend per diem monies and all that kind of stuff after session's over?
You may be right. But I think the representative certainly at the testimony the other day really wanted to get a group together to look at this. And even though I did give her, and she had previously the Supreme Court Study Committee on a similar issue, I think it's very important to this group of folks to look at this.
Well, one follow-up, if I could, Mr. Chairman.
Sure.
Well, to that, I mean, couldn't she just bring a bill or a piece of legislation that dealt specifically with this, so we could dig into those numbers then and deal with it that way, through this committee process, without having to study it, since we're just looking at one statistical issue here?
I can't answer that for her.
All right. Thanks, sir.
Representative Cook.
Thank you.
All right. Mr. Clark.
Just to follow up on that to Representative Cook. In the last committee meeting we had, there was people who were not necessarily for bail reform that also wanted to get the data. Like there was a lot of data. So it was like both sides of this issue wanted to really have a study committee to dig into the issue a little bit more, I guess, to kind of prove what, like their side, they both had points, but the data, they didn't have all the data together, and both sides wanted to get the data. So that was kind of a unique situation where the people opposed to the bail reform was also encouraging to have a study committee.
All right. If you would, Chairman Jaspers.
Make a motion to pass.
Do you have any other changes?
No, sir, I believe we're
All
good,
right.
Julius.
Does everybody understand? We've just sort of cleansed it a little bit and got the some of the mandates to try to steerage. So what's the will of the committee? We have a motion? We have a motion to pass. Do we have a second? Mr. Alcom.
Thanks, Mr. Chairman. I have a concern about the last clause of changing the whereas, of having it so broad as to be to analyze the available data about the jail population, because that's a broad circle. And then there is a comma to limit it to those in pretrial, but the charge is to analyze the data about the jail population in Georgia generally. So I think that should be tightened up, and I'd be happy to offer an idea on how we might be able to do that.
You have an idea, you're recognized to address it.
Thank you, Mr. Chairman. To change it to finds a need to analyze the available data about Georgia's pretrial jail population held for nonviolent offenses and to consider potential policy proposals for pretrial incarceration.
It's fine. That's fine.
That'd be fine.
Thank you.
All right, so you wish to make that as a subsequent motion?
Whatever the procedural path forward is, yes, sir.
You want to amend the amendment?
Yes, sir.
All right. We don't need to amend the amendment. Julius, is he?
I didn't catch the change.
Do you have that written down?
I do.
Forward this over here to lead council, please. Chairman Jaspers, you in favor?
Yes, I am.
That?
Appreciate his addition.
All right, so we. I don't think Mr. Norris wants to be heard on this. That sounds pretty good to you, doesn't it? Very good. You're the best one testifying today. You didn't have to get up. All right. We have a motion to move H.R. 1416 as amended. Do we have any other discussion, any subsequent motions, any comments? If not, all in favor say aye.
Aye. Aye.
Opposed? No. Ayes have it. Now we're back on to Senate Bill 348. All right.
There you go.
Now, Mr. Jaspers.
Okay, you got two amendments, and got one hot off the press, AM 410363. This one's, I think when you read through it, this is one where we would like to make the school security plans in public education not subject to public scrutiny, the Open Records Act. And we're pretty defined about it. The action plans of local law enforcement, action plans for the response and any movements of students, school personnel in response to incident of violence. This came to us Sunday night from a local sheriff that had a request in his county for the access of their school security plan. And he called one of the governor's floor leaders, and Representative Rhodes called me and said, is there a way that we can fix this and fix this quick? And I'd like to offer that amendment and you can read through it there. I'd be glad to answer any questions. There's been some talk that there is some immunity from it now, but this will make it definite and clear. That's why we're doing it.
Very good. Any questions?
Chairman, I have a question. I just wanted to make sure I understand the concern, the broader concerns about with this new amendment you just presented.
But I think the broader concern is that, local law enforcement, if they're in the schools with their own law enforcement and the school administrations want to make sure that they have a plan that the bad guy can't get it. There's someone that may do them harm, I guess is the simple way to put it. And so this will keep it within them. We're not talking about fire drills and things like that. These are these true serious incidents that we list in the bill.
So that, and if I may, Chairman.
You can.
So the concern is that people may abuse, having access to the plan.
Yeah.
Because obviously we want to make sure that the community is aware that we have good plans, but access to that plan may be abused to circumvent the plan and therefore do harm.
Right.
Gotcha. Just want to make sure I understand the purpose. Thank you.
All right. Well, I started to ask if we have any other questions, but obviously we do. Let's start down on the other end of the table. Number 28.
Well, I just wanted to say, when I was the Homeland Security Director and I first went in 2004, we got an open records bill passed because I didn't start any planning process because they would have been subject to open records. And GMA and Homeland Security together, but I just wanted to say I'm not certain. People still have the right to have a Superior Court judge have an in-camera inspection. I had many open record requests about some of the things we were doing, and the judge ruled on our side every time. But GMA, which has been doing this for 20 years now, doing school planning, is part of the same structure. But when we changed some of the statutes that appertain to criminal acts last year, I'm not sure that it would be covered now. So this is a good bill.
Yeah, thank you, Colonel. Julius, our fine learned legal counsel, he and I sat down and really studied it the other day to make sure this addressed what we wanted to. Thank you.
Good. All right, we have, and you're proposing that in the form of a motion.
Yes, sir. I'd like to make a motion to amend, which number is it? 340, Senate Bill 348, with AM 0363.
All right. Mr. Hoffman.
Thank you, Mr. Chairman. I have a question for the author of the amendment. Would this, and I certainly understand the intent, but would this prohibit a parent from asking and being provided information as to whether or not their child's teacher was armed?
I would hope that it would.
Okay.
All right. Any further movement? All right. Before you have LC 41-1560S as a committee substitute. I need a motion to pass this.
I have another amendment.
Let us move on. I want to get
okay. Got that one. Let's do that.
Get some of the process done. Do I have a motion as a committee substitute? Do I have a second? Subsequent motion. If you'll take your last one and you've already made the motion and a second for that, there's your second motion. Now, will you have another?
I do,
right.
Mr. Chairman. This one I'll have council read in just a minute, but I'm going to tell you why we're doing it. I think Chairman Powell and I and others, Vice Chairman Clark, had a lot of discussion with those sitting out there that are probably going to bring us strawberry cake soon, I would imagine, for the committee, and not just us, but about discussion about what's going on in this 1,500-foot area. I think it's kind of enlightening to me that our school are having to go outside into that 1,500-foot area to patrol. I think as Chairman Powell said, that some local law enforcements have just let them do it. Some have advocated them to do that. And so what the amendment that Julius is going to read is really to let us know. We would like for the Board of Regents and TCSG that this bill addresses is what's going on in that 1,500 foot, any criminal infraction. Take a list of it, report it to the chancellor's office. He'll kick it back to the chairmen of the committee, just so we can know. And I think, as we've all known, school security is very important to this committee and wanting to know what's going on. And I think, we have federal law that really dictates what goes on within the campus, and we'd just like to know what's going on in that 1,500 foot area that's out there.
All right.
And Julius, you want him to read the amendment, or?
Sure, I'm sorry, go right ahead.
Yes, sir.
Julius.
All right, this will be a new subsection. LC 411560 will make it a new subsection in 20-3-72, and it'll say campus policemen and other security personnel shall report any criminal offense to the Board of Regents that occurs upon, I'm sorry. Okay, I'll start over. Campus policemen and other security personnel shall report any criminal offense that occurs upon any property that is within 1,500 feet of any property that is under the jurisdiction of the board. Such information shall be collected by the college or university and reported to the Board of Regents and the chairpersons of the House and Senate Committees on Public Safety.
Yes, sir, that's correct. And also, that was his handwriting he was reading, not mine.
All right. Well, we're all lit up here now. Mr. Collins, we'll just go around the clock backwards.
I just want to make a statement about this proposed legislation here. It seems to me that it's a solution in search of a problem. Usually when we have, bills and we're vetting bills,
Punch your button, Jay.
we have people who come and sit and they give testimony as to why we need to change the law. Now, I've not heard that with this piece of legislation. I've heard some rumblings about why we're doing that, and I know there's been a compromise made to some extent with the university system. But when you start off on an island, and you don't make it back to shore, you're still drowning. So I think this compromise here still leaves the university system hanging out somewhat. I don't think they're giving pushback simply because they're just not gonna do that and make a big ruckus about it. But at the end of the day, my colleague, Mr. Petrie, here talks about safety, and at a time when we need to be concerned about safety, especially around some of these off-campus housing areas. I can only speak for the area where I come from over in West Georgia. We have a great relationship. We refer to it as the town and gown relationship, where the county and the city and the community really work well together. And I want to say that this committee has postured itself in the past that when we have issues, we're fighting for Second Amendment rights. We don't encroach upon those law-abiding citizens, and encroach upon their rights because of a few bad apples. And so I would certainly hate to treat the university system as a whole because of a few bad apples. That concerns me here as a member of this committee. And I would just like to caution the committee before you take action on this legislation to just think about that. Don't let a few isolated incidences throughout the state ruin it for a lot of communities where this current law is working well. And Mr. Chairman,
I'm sure that you'd probably be speaking to the fact that my tax money paid by my constituents is helping to pay for your security in Carroll County.
that's not true.
That is true, because the taxpayers' money that goes to the university system of Georgia, they're patrolling outside of a jurisdictional basis. And in a lot of cases, we have had reports of campus police running traffic patrol several miles off of campuses. Whether that's true or not, it's certainly been reported. And that's part of the process we're trying to get to. Mr. Glanton.
Thank you, Mr. Chairman. I have more of a comment than I do a question. I just want to make sure that in our efforts to do due diligence, that we make it clear that this is no way an indictment of our local law enforcement. I've heard several folks say that we're doing this because the locals are not doing their jobs and we need to protect them. I want to make it clear that at least for this representative, that is not the plan here. The plan here is that they augment, supplement, whichever way you want to put it, the local law enforcement. But by no means indict those fine men and women who every day police not only our campuses, outside of our campuses and beyond. And so I want to thank them for their service and make sure that this is not an indictment on them.
Good. Ms. Taylor.
Thank you, Mr. Chairman. I've noticed several different places in the bill, and we've now, shifted things around several times. Everything that we're talking about, we've usually referred to the Board of Regents. I want to make sure that the technical colleges are included in each one of these. And will it in any way affect the private schools? Because there are some private schools that have their own police departments.
Chairman Jaspers.
I'm just, I know you're looking at me, Madam Chairman, but this isn't my bill to answer that. But if you look at the underlying bill, I think the original bill came from, if I'm not mistaken, through TCSG, as Neil testified. The Senate made some changes to it. Just for chronological, Jay, this is a correction to the changes the Senate made back to original law, and then we've made a few amendments to it. And as Chairman Powell said, limiting their traffic control. Does that make better sense? Okay.
But I just want to make sure it's all inclusive, who's in it and who's not.
I don't know that this includes private.
No,
I don't
it does
think so.
not.
They're not 40. Yeah. Okay. Yes.
Okay.
Number 26.
That's me, Mr. Chairman.
You're recognized.
Thank you, Mr. Chairman. I don't know if this is not a pro or against, but to a comment, Mr. Chairman, you made earlier, and it actually sparked a question in my mind. If a campus officer is outside of 500 yards, 1,500 feet, whatever it may be, and they stop someone for a traffic violation, who does the money go to? The municipality, the county? Where is the university incentivized, or
their municipal courts? If
Okay.
it's in a jurisdiction or wherever the appropriate court. Maybe probate courts in some areas, maybe municipal courts.
okay? So the university doesn't get any of that money.
No.
Okay. Thank you, Mr. Chairman.
Thank you. All right. Mr. Glanton again.
Sorry, Mr. Chairman. Now, when we don't say anything, you get on us, and when we say something, you get on us. But at any rate, Mr. Chairman, I just had a question in regards to regular employees. If they were to bring in a temporary group for whatever the case may be, whether that be an event or something of that nature that's happening on campus that calls for an increase in police personnel beyond the regular employees, how does that work? Do they have the same ability to go utilizing that 1,500 feet jurisdiction as a regular employee? Because it specifically talks about regular employees. It doesn't give room for part-time, doesn't give room for temporary, doesn't give room for any of those.
As I understand it, any part-time employees that's employed for special events would work under whoever that university system. If it's the campus police department, then they would work under them. If they're not post-certified, then they can't carry a weapon. So they might be checking tickets, or they might just be providing security services. But in my personal opinion, I think they're always in radio communication with those who are sworn and post-certified.
So if I'm a temporary employee and I'm post-certified and I chase a person that's a crime that's originated on campus and I pursue that individual, am I authorized to do so under this language because it specifically relates to regular employees of that police department? So I understand that they come under the jurisdiction of the department, but as an individual, if I'm called on to do temporary duty, do I have the ability to carry out and pursue as if I was a regular employee?
Depends on what the job is. If you're not post-certified, then you do not have law enforcement. You're not given that responsibility.
I hate to be difficult.
A security person or someone hired as a regular employee, then they can work with, but they can't make arrest.
Okay, and maybe I'm not saying it right, Mr. Chairman, because you have law enforcement officers who are maybe retired but still maintain their post-certifications that may be called on to augment the force because of a special event. My question is, all things being equal, other than that person being a regular employee, can they pursue as if a regular employee under this language?
I think if you're saying if they hire a part-time or somebody to work with that police department on campus, if they're not post-certified, they cannot exercise law enforcement functions. But they can do certain things to assist, such as if they see someone, then they that's violating the law or whatever, then they can certainly report that and get certified personnel over there.
So, okay, maybe I'm naive. Maybe it's one of the law enforcement officers on this committee can help me. If you're a retired officer, a law enforcement officer, can you still be currently post-certified?
Yes, you can, unless you take a disability retirement, then you're prohibited from being a certified law enforcement officer. But as a matter of course, what's going to happen here is that somebody that's working part-time isn't going to be in one of the university vehicles out patrolling. They're going to be assigned to some other position where the people who are full-time are going to be in the car actually doing the enforcement work. It's just not going to work that way. And typically, if they're retired, they're probably like me, and their better days of enforcing the law are behind them.
Thank you.
Thank you. Mr. Werkheiser.
Thank you. Could we go back and catch the comment from Representative Chairman Tankersley, who is my expert on this opinion in this area?
Would you like to be heard, Representative?
Sure. Would you like me to do it from here?
Just whatever suits you. It's your pleasure.
I'll just see in case I get shaky knees. I'm by no means an expert. I am Jan Tankersley, and I do represent House District 160, and the heart of Georgia Southern University is in my district. I also have a grandson there, so I'm concerned about campus safety, and I would agree with a couple of representatives that have already spoken that we don't need in any way to diminish the amount of security that we have on our campuses. And we have a wonderful working relationship with our local police department as well as our campus police. And as a matter of fact, by mutual agreement, they welcome the presence of the campus PD within that 500 yards. And with that being said, they have one officer per shift in what we call Zone 4. And Zone 4 simply circles our campus. And so when you leave Georgia Southern campus, you're immediately in the Zone 4, which is the 500 yards out. We have approximately, let me take a breath, 26 or 27 very large apartment complexes. And I'm guesstimating that there could be as many as, I would say, 12,000 students in the fringe area around the campus. That area also attracts the criminal element, unfortunately, and so a lot of our problems are around the campus within the 500 feet. So it is helpful that our units do work very well together, and I would encourage this committee to consider allowing them to continue with the mutual agreement that they have with the jurisdiction, the Statesboro PD. And other point I wanted to make is that our campus PD assisted just in these past 12 months with 83 assists. And according to our Statesboro Police Department, you know, it really does help them a lot. It helps our students, and it enhances the safety of the students. So that's mostly what I had to say, and I would try to answer any questions the committee may have. And I don't know, I can only speak to my area. I can't speak to other university campuses and what they encounter or what the working conditions are. I am concerned, I will say one other thing about the amendment. I understood you to say the results would be reported back to this committee, and would that information then be further distributed to those of us that have a university or a college that would, you know, you would be getting reports? And those are all the concerns, and thank you for your patience. Thank you.
Thank you, Representative. Mr. Hitchens.
And I would just say that's more the standard rule across this state. I've dealt with almost all the campuses around with in my days in law enforcement, and there's a lot of mutual aid that goes on. When things occur on campus, the local police department goes in to assist. When they occur in surrounding areas, and there's one lone policeman or two, and they have to deal with some problem that's pretty significant, the campus police come and assist them. And I know back when I was a commissioner at the Department of Public Safety, we had a significant problem which hadn't gone away completely over at Georgia Tech. There's one Atlanta police officer assigned over there on the midnight shift. And we, in fact, assigned 2 or 3 troopers over there every night from our criminal interdiction unit, and just to have a police presence and be seen, and that really slowed things down. But the Atlanta police officer, nothing against them, they answer calls all the time, and they have to be off scene. And a lot of those Georgia Tech students study half the night, and then they want to go get a donut and a cup of coffee, and they walk down the street and they get mugged and robbed, and some of them severely hurt. And I think it's all a matter of working together, and it works probably better than most people realize, because the aid is on both sides. So it's a positive thing, and I don't know what the problem is here. I've never experienced it before, but most of the places, I just got done with being on the study committee for Savannah State. They've had some serious problems down there, and we tried to devise some new security procedures to try and curtail some of the problems they've experienced in the past. And you know, the local police department, the sheriff's department, everybody's been involved in it. So.
All right. Anyone else wish to be heard? I believe we were in the motion of taking subsequent motions or amendments. You've got 2 on?
Yes, sir.
Is anyone else? You got anything, Mr. Collins? I think you have. All right. All right. We've got what we have in front of us, and we've already gone through all of this. So we've got a motion. We've got a motion and a second on the substitute, and we have got a motion and a second, so we need to vote on that first. All right, we have a motion and a second, LC 411560S. All in favor say aye. Opposed? No? All right. We have 2 motions. And first one was, actually we got 3 motions. LC 410366 is the amendment to the committee sub. This is the one that changes it back to 1,500 feet and puts that description back in there. All right. Any questions on that? If not, all in favor say aye. Aye. Opposed? No. All right. Mr. Jaspers, we have a motion on the floor, LC 410663. Any questions on it? If not, all in favor say aye. Aye. Opposed? No. All right. This is the one, this is the amendment about about the safety planning. All in favor, raise your hand. Ayes have it. It's a little bit weak in the verbal vote there. All right. And then you have another amendment, Mr. Jaspers?
It's the one that legislative
One-
council had.
Now, does everyone understand that, or would they like to hear it read again?
I'd like to hear it read again.
If you would, Julius?
Campus policemen and other security personnel shall report any criminal offense that occurs within 1,500 feet of any property under the jurisdiction of the board. Such information shall be collected by the college or university and reported to the Board of Regents and the chairpersons of the House and Senate Committees on Public Safety.
Basically reporting back through the Board of Regents. Mr. Clark?
With the way that's worded, does that apply to the university system and the technical college system in the way that it's worded?
Sure.
Okay.
I guess what I just read out would be as it would appear in the, in 20 -3 to 72. And then we'll take that same phrase and put it also in
The text goes.
2439, making adjustments where it says Board of Regents, it'll say Technical College System of Georgia.
Rawlings?
It's an annual report.
How do you want to do it, Mr. Jaspers? You want it as an annual report or a biannual report? What's your preference?
I'd rather do it
Annually?
January 1st.
All right. All right.
They said do it every day.
All right. Does everybody understand the motion? If so, all in favor say aye. Aye. Opposed? All right. All right. So, now we have in front of you the whole ball of wax as amended. All in favor say aye.
Aye.
Opposed?
No.
And I think the ayes have it. Ladies and gentlemen, thank y'all for your tolerance. And this meeting is now adjourned.
Hey, Rick, are we still having the 3 o'clock?
Yeah.
Higher ed at 3?
Hey, I've had to take yours out.
Why?
JJ will call you tonight.
Oh, yeah, and I'll tell her what a shithead her daddy is. Who's they? My fact, take care of you because you got a college up there. All right.
The schools don't like it. I haven't heard any opposition.
It's a good data sheet, yes.
Thank you, sir. Thank you for helping us.
Back when that's what I did.